compelling circumstances, my lord, I am praying for leave, my lord. This relates to a matter of, my lord, retention of quarters, my lord. I am my lord, commercial clerk, my lord. I am entitled to a type 3 quarter, my lord. But a person, my lord, who is not entitled to the type 3 quarter, my lord, an office order has been issued, my lord. That needs to be stayed, my lord, because, my lord, as it is, my lord, there are very few vacancies of quarters, my lord. And the quarter I'm occupying, my lord, is damp. The children are suffering. School-going children, my lord. Small school-going children, my lord.
File it in the department, we'll
Lord,
see.
kindly fix a date, my lord.
No, file it.
May I God's leave to make one contempt application of your lordship's order dated
Please come on 2nd of December.
2nd of December. Right.
But an application in connection with the writ petition. The coordinate bench of Justice Bharadwaj has already directed CBI inquiry into Lord illegal taking over of Lord Jute mill, Agarpara Jute mill. But here, a registered document has been interpolated by the registering authority after it is registered by handwriting. We have filed a writ petition. We have taken out an application in connection with that. Lord, it is extremely, Lord, disheartening that this is entire the state machinery is against this. Now, Lord, we have filed an application. Let it appear before your lordships, Lord. Then we'll serve and come back, Lord. The difficulty is after the document. I'll show you, lordships, Lord. The document is one. They have with handwriting put another premises number to Lord take over the jute mill. It's a 500 crore property. 3,000 workers are there. It's creating a ruckus in the entire thing, Lord.
Why? What is so emergent about it?
Emergent is, Lord, we have taken out an application, Lord, because on the basis of that document, he is getting other licenses.
Who is getting other licenses?
Lord, I tell you, Lord, Lord, Agarpara Jute Mill, this is concerning the Jute Mill. It is being always, Lord, for the last 50 years being run by one group of company, that is Agarpara Company Limited. That has been established before Justice Bharadwaj. Justice Bharadwaj directed CBI inquiry. One fine evening, police came on their own. Lord, there was some dispute. Police came with armed forces. They took over possession and removed us from there. Then this manipulation, forged document
and
started
what
coming.
is Justice Bharadwaj's order?
Justice Bharadwaj directed CBI to inquire into the aspect of takeover possession. Now that
and
has
this
been
is in connection with the same thing.
No, not same thing. They have manipulated an agreement with handwriting. They have inserted the premises number. So, my lord, with this
Why to approach the same honorable
no,
court?
that is for my lord, that possession matter. It is another document. With this document, they are getting other licenses. They are showing.
And it is in connection with the same writ petition. You say
No,
it's an
not same.
application.
That's the writ petition is disposed of. Justice Bharadwaj has disposed of the writ petition. Here we have challenged that.
So this is a fresh writ petition.
Fresh writ petition. In connection with that, we are taking out an application. This Justice Bharadwaj has disposed of the writ petition.
Where is the pending writ petition?
The writ petition is there. My lord, application we have taken out. Let the application come.
Where is the writ petition?
Before your lordships. It's received.
There in the list.
No, not in the list. Let it
It's
come on this
outside
Thursday.
the list.
Let us come on this Thursday. We will serve the application.
Thursday means tomorrow.
Or, Lord, I can only pray to your lordship, Lord, whenever your lordship fixes.
First week in the month of December, it
your
will
lordship,
appear.
Lord, takes up the applications on
Thursday.
The Thursday week. May I come back, Lord? Thursday week.
Thursday fortnight.
Thursday fortnight. We shall serve and come back.
Your lordship, I want to. I am praying for a leave to file a writ petition against eviction of some vendors of Satragachi Jhil in pursuance to the order of the NGT, but NGT clearly directed to remove the encroachers with due process of law. But these 12 petitioners were never served any notice for eviction. They have not given any opportunity of hearing.
Who is taking steps for eviction?
Railway is taking a step.
Railway authorities.
Yes.
Today is Wednesday. Come on Monday, 25th.
Date of eviction is 16. They are taking a step on 21st. Tomorrow. That is tomorrow.
And you come today.
I came to know on the 16th. Notice was issued on 16th for police.
You should have moved faster. You are aging, and it is showing. Tomorrow.
Not on 5th.
Serve notice.
May I serve the notice to on
yes, serve notice.
GP and Additional Solicitor General.
Yes, and anybody who appears for the railways, because you said it's being done by the railways.
Yes, General Manager.
You have to serve on the government.
Serve on the learned counsel who appears for the railways also. Ensure that somebody is present for the railways.
Not only one aspect. On 5th, Lord, let it appear, Lord. If it appears, Lord, at the bottom of the list, then
let it appear. Then the position can be altered.
Very well.
May I permit to mention the application, my lord, for releasing the pay and the salary, my lord. Petitioner is not getting salary.
Petitioner is not getting salary.
Salary, my 2 months on the kind of matter is pending, my lord.
Why don't you go before the Group 6 bench? Service matter? Why are you here? This court cannot take up service matters. Yes.
My lord, I beseech before your lordship, my lord, to kind leave to file, my lord, a writ petition. My lord, the petitioner is a additional district judge. My lord, may
You
I?
want leave to file writ petition?
Yes, my lord.
Stopping you from filing it.
My lord, so that it will appear urgently, my lord, because there are several urgencies in this
What is the
matter.
urgency?
Urgencies, my lord, there was a dispute which was addressed before Honorable Chief Justice. A contempt application was preferred by the additional district judge. Certain things I will go into that in details. But as soon as contempt application was filed, my lord, before Chief Justice, he was served with a notice of transfer. Now, my lord, I am not only on the malafidness of the transfer, but there are certain other issues which has to be gone. I am not against transfer. Had I been against transfer, I would have
Then
preferred.
there is no urgency. The other
No,
issues
my
will
lord,
be
there is
gone.
why there is an urgency, my lord. Today is the last date when there will be a deemed charge. Now, if it is a deemed charge and then he is transferred to a different district, then my lord, the contempt application is not heard. Then the entire
Contempt
scenario.
application will be heard by some other
Yes,
bench.
yes, my lord.
Then what is the urgency in the writ petition? File it in the department. Yes.
Under compelling circumstances, may be permitted to mention this, madam. This is the senior citizen, the petitioner is a senior citizen and is suffering from various elements. Some admitted dues is pending before the
Dues for what purpose?
for construction for completion of the work under the West Bengal State Electricity Board, my lord. And it is covered by your lordship's judgment, my lord. Your lordship given the direction of many cases, my lord, for releasing the admitted claim, my lord. So your lordship kindly take up this matter, my lord.
Where is the matter?
My lord, my lord, it is not in the list. Well, any day, my lord, your lordship, my lord.
Second, it will appear. Second.
With your lordship's kindly.
Yes.
May I have your lordship's leave to move an urgent unlisted motion? My lord, this relates to my lord tender. Completion has been done. The project has been handed
Tender
over.
floated by which authority?
My lord, video floated, but the work of my lord, health department entrusted.
Video floated? Go before the other bench. No, group 5 bench is
No,
there.
this is my lord, tender of CMOH. The tender was assigned to the video to float.
Yes.
My lord,
CMOH under the panchayat. You go over there.
CMOH health department, my lord, not
Yes, health
covered
department
under.
is there. But then you go before the panchayat bench.
With your lordship's kindly, my lord, may I mention item number 26 of your lordship's release today, my lord. I mentioned the matter yesterday also. The financial bid is going to be opened any point of time, and but the other difficulties, Mr. Vikas Ranjan Bhattacharya is leading me. Mr. Bhattacharya requested me to mention before your lordship. Your lordship takes up this matter any time today, my lord. Mr. Bhattacharya is in some difficulty tomorrow and day after. Will not be present.
Listen, by this way, fixing up
Lordship,
matters is difficult.
No, lordship, only difficulty.
Please wait, let us see how much I can
Permitted to mention.
fast.
Kindly
I'll
consider,
take up.
my lord.
Permitted
My
to
lord, the financial bid, if it is open.
26 you said.
Yes, item number
Please wait.
26.
Am I permitted to mention a matter, ma'am? The petitioner is, this is a third round litigation, ma'am. The petitioner wanted
What do you want?
a petitioner wanted to go out of India, my lord, but the PCC is not granted by the police authority and passport offices, my lord.
PCC?
Even police clearance certificate, my lord. Even after getting NOC from the lower court, neither the police authority nor the passport officer guaranteeing the PCC. Only entire visa interview has been done. Only the PCC parties remaining with the US visa authority, my lord. But they are not granting PCC even after getting NOC.
Why are they not granting?
They are telling that the case is pending. Even I obtained NOC from the lower division. Even then they are saying, no, on this way we cannot go.
And when does the person want to go out?
When
Well, for what purpose?
for meeting his fiance, my lord.
Meeting fiance? Let him wait.
But
Online
entire
meeting.
application.
The petitioner commissioning couple who lost their 16 years old only girl child in April 2024. Thereafter, the husband at the age of 56 years and the wife at the age of 46 years decided to opt for
What
the
do you want?
IVF
What do you want?
for urgent listing of this matter.
I'll deliver a judgment on Friday. See what happens to it and then mention.
Your lordship, just a minute. There is a coordinate bench decision on article on section 21C, and as there.
I am aware of the decision. It has been cited yesterday. Please wait. Please wait till Friday.
For urgent listing. The difficulty is a mobile tower in a congested area is going up rapidly. Anytime the connection will be bread. Once the connection is granted, it I can get the clock.
Why? There are various judgments where mobile towers have been stopped. They have been pulled down. In fact, you also appeared when I was taking up Group 5 matters. Then
That matter, my lord, was in a different, my lord, context. my lord.
whatever.
My lord, no TOT rules have been followed, my lord. My lord, there are certain specifications, my lord, where my lord.
And then appeal matter is also there.
Appeal matter is the context are different, my lord.
No. This is setting up of the mobile towers.
Setting up, my lord, the context is different, my lord, in the sense, my lord, where, my lord, the petitioner is to go. But here, my lord, the DOT rules, my lord, has been clearly violated. Without any, my lord, that part.
It will appear on second.
Wait, may I have my- the tender document, my lord, whether the tender document is required to be in spite of that, my lord, they have published that in their website, and my lord, the matter was appeared at the petition stage, and everything is to be abided by the result of the petition, my lord. But the thing is that, my lord, the DOT has issued the work order and work is about to be commenced, my lord. And the intending, my lord, the tender, my lord, who could not participate in the
If there is already an interim order, any steps taken during the pendency will abide. Very well. If you are aggrieved by that,
my lord, I have already made an application for injunction, my lord.
sorry, you can prefer appeal for non-granting of interim order.
Your lordship. Mention before your lordship during third week, your lord. This is the third week, your lord. If this can be, your lord, this is the order. Your lord.
29th of November for hearing.
Your lordship.
Yes.
My lord, 2 years back.
What do you want? Tell me.
My lord, inclusion in the list.
Yes, second. Come and mention on second.
Your lordship. My lord, I am paying for inclusion in the list as court application, my lord. Earlier it was adjourned and directed it to appear in monthly list of January on the ground of pendency of
January.
on the ground of pendency of SLP with liberty to mention, my lord.
All right.
SLP has been dismissed, my lord.
All right.
So, my lord, this is for implementation of the order, my lord. So I am paying for inclusion in the list as court application.
Very well. Give
Your lordship.
next week.
My lord, may
Next week it will appear.
May I
Give
mention?
notice.
Your lordship. Your lordship, this matter, my lord, WPO 920 of 2024, I had mentioned this matter on Monday, your lordship, for withdrawal, wherein your lordship directed to serve notice to the other side. So accordingly, my lord, I have served notice to the other side, and yesterday, my lord, kindly leave be granted, my lord. We have instructions, my lord, from our client for withdrawal of this writ petition.
Is the matter appearing in the list?
My lord, this is appearing in the monthly list of December, your lordship.
Monthly list of December.
Yes,
Which
your-
year?
Yes.
Which year? December of which year?
December of this year.
It is appearing. The list of December is yet to be published.
Yes, your lordship. This matter came up on the 8th of October for hearing in the court of Honorable Justice Shampa
Whoever,
Sarkar.
then
Your lordship, an interim order was not passed in that regard. So the next hearing in the with respect to the matter is supposed to come in the monthly list of December.
supposed to come.
Supposed to come
Let
in the
it come.
December, but in the meantime, your lordship, the relief sought for, we have instructions from our client that there is no longer any requirement to
So right now
continue.
the matter is not there in the list.
Right now, the matter is not.
Give.
Yes.
My lord, may I have your
Prosecution. Only
Lord.
the mentioning slip will be given.
My lord, the proof of service I'm also attached
Yes,
with
the
it.
proof of
My lord,
service.
may I have
Obliged,
your
my lord.
lordship's leave to mention one writ petition, my lord. This was originally filed in the month of August, my lord. But this writ petition is challenging an order of the patent office, my lord. My lord, your lordship knows that after the from 4th of November, the intellectual property division has been commenced in our High Court, my lord. Now, I believe, my lord, it's my humble submission. Your lordship doesn't have the determination. It is required to be released, my lord.
Very well. For release.
Grateful, my lord.
May I have your lordship's leave to mention item number 1201 of the monthly list? I had mentioned this earlier, my lord. If your lordship does not entertain my writ, I will have to file a suit. The suit will become barred by limitation in January 2025. That's why, my lord, whenever, my lord, before the vacations, if your lordship finds time to list it, I will be very grateful.
It is in the appellate or the original side?
Appellate.
Appellate side.
Yes.
2nd of December, the matter will appear in the list. Give the number.
I'm very grateful.
My lord,
And serve notice, please, upon
will-
the other side.
my lord, may I be permitted to mention this matter, my lord, to move on urgent basis. This pertains to my lord Jalpaiguri Circuit Bench, my lord. My lord, challenging the order passed by the my lord DRT Siliguri, I have preferred already.
When is the next bench sitting?
My lord, since my lord Monday.
Next week, take it.
My lord, what happened, my lord? I have
To go there.
no, my lord. What happened, my lord? Yesterday, the bank authority came and put padlock in our residential house. That's why, my lord, we cannot enter into our house. What happened, my lord?
No, padlock has already been put. Now you want to remove the padlock.
Yes, my lord.
Yeah, Monday before the circuit bench, please mention.
My lord.
Because it will be
My lord, may I
difficult.
permitted to mention one matter? I'm praying for upgradation, your lordship.
Come on 2nd of December,
My lord,
please.
may I permit to mention on urgent motion, your lordship, quotation amount was not received for non-payment of other person, alleged dues of other person, your lordship. So no connection was given to the petitioner, your lordship. So
Where is the matter?
today it is running on daily list on item number 217.
Yes.
So
Please wait for your turn. Yes.
ম্যাম DRT3 রিকভারি অফিসার ব্যাংক মিলে আমার বাড়িটা 24শে নভেম্বর 2021 আন্ডার ভ্যালুতে বিক্রি করে দিয়েছে। টিল ডেট না আমাকে হিসাব দিচ্ছে না কিছু করছে, এবং যে সমস্ত ডেট গুলো দিচ্ছে, যে ডেটে মামলা হবে না সেই ডেটে দিচ্ছে। এখানেও আপন মেনশনিং 1634 লিস্টেড আছে। আমাকে একটা ডেট যদি দেন মামলাটা শোনার জন্য, এত হ্যারাস করছে আমাকে, আমি পারছি না।
আপনি ডিআরটি তে যাননি?
ডিআরটি 6 লাখ টাকা,
ডিআরটি তে
ডিআরটি তে না, ডিআরটি তে মামলা ডিসমিস করে 6 লাখ টাকা প্রি ডিপোজিট চেয়েছে, সেটা আমার ক্ষমতা নেই। আর DRT3 রিকভারি অফিসার ব্যাংক মিলে 24শে নভেম্বর 2021 আন্ডার ভ্যালুতে প্রপার্টিটা বিক্রি করে দিয়েছে, এবং যে পোর্শনটা বিক্রি হয়নি সেটাও আমাকে হ্যান্ড ওভার করছে না। আমি বারবার ধরে বলা সত্ত্বেও যে ডেটগুলো
আপনি কি বাড়ির মালিক?
না, আমার মা মালিক, আমার না ব্যাংকের লোন ছিল।
আচ্ছা,
তো
আর আপনার উকিল বাবু কোথায়?
উকিলবাবু পয়সা নেই বলে দিতে পারছি না, কিন্তু উকিলবাবু যিনি আছেন, যিনি ব্রিফটা করেছিলেন এই কেসে, সেই ব্রিফটা নাকি এতটাই বাজে হয়েছে মামলাটা নিতে চাইছে না, কিন্তু বলছে নতুন করে ব্রিফিং করতে, কিন্তু আমার পক্ষে সেটা সম্ভব নয়। কিন্তু উনি আমাকে বলেছেন যদি এটা হয় তাহলে উনি করবেন, কিন্তু
কোথায় উনি?
ওনাকে আমার ডাকতে হবে ম্যাম।
ডেকে নিয়ে আসুন। আপনার উকিল বাবু থাকলে তো আপনি নিজে কোর্টের কাছে কিছু বলতে পারবেন না।
ওনার থেকে আমি এনওসি নিয়ে নিয়েছি, আগের যিনি ছিলেন। এবার এখন আমি যতক্ষণ ডেট পাচ্ছি বারবার ওনাকে
না,
আনতে,
ওই রকম ভাবে করা যায় না।
তাহলে আমি
আপনার
ওনাকে,
যদি আর্থিক অসুবিধা থাকে আপনি লিগ্যাল এডের
না
সাথে
তাহলে আমি
যোগাযোগ
ওনাকে
করুন।
কি একবার ডেকে নিয়ে আসবো পরে একবার ম্যাম?
না, আমি এখানে উপদেশ দেওয়ার জন্য নেই। আমি এখানে মামলা শুনে তার শুনানি করে তার যা অর্ডার হবে সেটা দেওয়ার জন্য আমি আছি। ঠিক
ঠিক
আছে?
আছে, আমি ওনাকে নিয়ে আসবো তাহলে।
আমি জানি না আপনি কি করবেন, আমি আপনাকে উপদেশ দেব না আপনি কি করবেন। কল দ্য লিস্ট প্লিজ।
ঠিক আছে।
My lord, I am for the petitioner. My lord,
দাঁড়ান। কখন নজরে পড়লো? কখন
my lord, on the last date, after your lordship granted me permission to put the name of the contemner, I have, accordingly, my lord, I have put the name of the contemner, Mr. Tushar Jati, who is the executive engineer, borough number 5, my lord. My lord, some develop.
It is wrong.
wrong name?
Yes.
Take the proper name.
He is not the Tushar Jati is not the actual.
My
Take
lord,
the correct
Somebody-
name.
And when the SWM, my lord was pleased to pass an order to consider the representation by the SWM, executive officer SWM. And after receiving the representation, they have inspected the premises and they have found that there is a unauthorized construction there, but no passage is there. And it is a unauthorized construction, some unauthorized, and therefore it has been sent to the department, building department for consideration. But that they have made mistakes. Now they have taken steps for hearing by the executive officer of the SWM. He has taken steps and he has served notice. And we hope he will get it, his client. And hearing is fixed on 26th. And
Of
sometime
this month, 26th of this month.
This month.
All right. I'll adjourn it till thereafter.
Yeah.
You take instructions and you take the name from your learned senior friend and add up the proper person.
Yes, my lord, before I took the name, at that time, I was
Maybe
told
he
that.
was there. Now he is not there.
Yes, ma'am.
Please come. Learned advocate representing the corporation submits that the name of the executive engineer within bracket civil borrowed 10 as mentioned in the contempt application is incorrect. Stop paragraph. Leave granted to the learned advocate on record of the petitioner to implead the proper person as alleged contemptor in the contempt application and serve copy of the contempt application upon the said person. Paragraph. It has been submitted by the learned advocate for the contemptor that a hearing has been fixed by the executive engineer of SWM department on 26th November 2024. Stop. The parties have been issued notice for appearance. Stop. Paragraph. Lists the matter on 10th December 2024. Stop. An affidavit of compliance shall be placed before this court on the adjourned date.
My lord, may I file the affidavit of service?
Yes, affidavit of service taken on record.
My lord, may I pray for one indulgence, my lord? After they have made inspection, my lord, they had asked for the copy of the site plan, which we have served.
They have served.
My lord, I have the received copy, my lord.
Keep it with you.
Deeply obliged.
I'm for the petitioner. This is my contempt application. This is the port matter, my lord, where lordship directed that goods should be released within 48 hours, and that they have not done it, my lord. Page
What
320
is the position now?
My-
Is anybody claiming?
No, nobody is claiming. Nobody is there. Nobody is claiming.
Even then, they are not
Even then,
releasing the goods.
No, not there. The order, your lordship's order is volume 3, page 2321. I have given them list also. Money also not they have got, and still they are not complying. Full list I have given 320, page 325 is the list which I have given to them. And they have taken the pay order also from me, 55 lakh.
You have impleaded 3 persons: appointed estate officer, the estate manager, and the authorized officer appointed on the public premises. Who is going to hand over these goods to you?
But the authorized officer has taken the position in terms of
That is separate. But who is to hand over the goods to you? Will it be the authorized officer?
Yes, my lord, yes.
Very well, please come. The petitioner alleges violation of the direction passed by the court on 14 November 2024 in WPO 1049 of 2024. Stop. Next. It is alleged that the goods of the petitioner have not been permitted to be removed despite payment being made in terms of the order passed by the court. Paragraph. Let notice be served upon the alleged contemptor number 3.
My lord, it may be served to both 1, 2, and 3 all, my lord, because, my lord, now respondent number 1 has really obstructed the course of justice.
Very well. Upon the alleged contemptors, don't give the number. Returnable on
Day of tomorrow, my lord, Friday.
Let notice be served.
I will serve today.
Contemptor intimating that the matter will appear in the list on Monday 25th.
My lord, deeply obliged.
Lordship, I came appearing on behalf of State Respondent led by Mr. Oyam Banerjee. Lordship, Mr.
My
Oyam
lord, I'm for the respondent. We have received the instructions, my lord. My junior will hand over the instruction. This is regarding the non-handing over of a deed, which was the IGR was issued.
What is the what does the instruction
The
say?
instruction is this, my lord, that the executant has to present himself before the registrar for completion of registration. The deed was presented. As per the statute, 4 months time is given for the executant to appear personally and do his biometrics and complete the registration. He did not appear. So we
No, but
could
then
not
on the date and at the time of registration, all biometrics are done. Then why is
No,
he
no, Milord. It was not done, Milord. That is incorrect. Biometrics were not done. It was signed, fingerprints were taken, and the deed was presented, but the executant was not present. If there's a provision, it can be done within 4 months. Now, Milord, those 4 months have expired, but they have not done it. Now, Milord, this is the position. It can be extended by another 4 months, but that period is
the
over.
executant was
Can
not
you take the
present?
page 68?
68.
Milord, may I address your lordship personally tomorrow? Milord? I'll show the provisions from the statute, Milord. May I address your lordship tomorrow?
I'll
On
show
this?
your lordship, my lord. It is on the basis of presentation. There are specific sections, my lord. I will not go into it. Kindly takes up page 68. This is my IGR, which has been given by them.
Listen, thing is, if the executant was not present at the time of registration, then
They
possibly
cannot issue this
registration
notice.
cannot be
Kindly,
done.
my lord, kindly see the first line. এই রশিদ খানি উপস্থিত করিলে দলিল ফেরত দেওয়া হবে।
Hmm.
It does not speak of the saying that I was not present, and without me being present, then how can they have given this document? It is their document. The original is with me. If my deed is incomplete, there is no provision that incomplete deed is there. Nowadays, there is no
So
provision.
it can be accepted subject to verification. I'll show the provisions, Milord.
Let them
May I
produce the deed
add,
before your lordship.
tomorrow?
Whether
I'll
it
show the
contains
provisions.
all the signatures and the biometric, let them produce the deed.
You hand over a copy to your learned friend also so that he gets to know what is the objection. Come.
Fine.
Instruction forwarded by the Additional Registrar of Assurances, Roman 2 Kolkata, dated 31st August 2024 is taken on record. Stop. Copy of the same served upon the learned advocate representing the petitioner. Stop. Not tomorrow, come on Friday in that case.
Fine. Yes, ma'am. As the Lord.
23rd.
Fine.
Jute by 22nd. 22nd.
I am appearing for the petition, my lord.
I am in number 6, item 6. I'm quoting.
Item 6 for whom?
Registrar of Company.
Registrar of Companies.
4 and 5, I'm for the Registrar of Companies.
All right.
My lord, may I just give a short background as to what has happened, my lord? My lord, I am representing the petitioners. They are the company and directors of the company, my lord. My lord, this petitioner, my lord, was incorporated somewhere in the year 1981, and my lord has only been listed with the Calcutta Stock Exchange. My lord knows Calcutta Stock Exchange is now going through the doldrums and has no business, but still I'm listed with the Calcutta Stock Exchange. Now, the authorized share capital of the petitioner is approximately 2 crores. Now, my lord, from my incorporation till 2018, my lord, there were no rules which required that I need to appoint a company secretary. Now, subsequently, my lord, by way of a rule, my lord, obviously the legislature has brought in a rule where I was required to appoint a company secretary. Now, my lord, as a matter of fact, my lord, there was delay in appointment of the company secretary, and my lord, I was issued a notice. Your lordship will kindly see the notice at page 24, my lord.
Yes.
My lord, kindly sees, my lord, there is a notice of adjudication. My lord, kindly sees the words, my lord. Notice of adjudication of penalty under section 454 of the Companies Act, read with rule 3.2 of the Companies Adjudication of Penalties as amended up to date. Whereas the company is a company, and my lord reads 1, my lord, recital 1, whereas the violation of the provisions of Section 203 of the Companies Act 2013 has been found. And whereas the undersigned is authorized to adjudicate the aforesaid matters in terms of Rule 3.1, and then that the nature of non-compliance and default is reproduced hereunder. Now, Malad kindly sees the contravention. Section 203(1) of the Act provides as follows. Every company belonging to such class or classes of company as may be prescribed shall have the following whole time key managerial person. Malad 2 is company secretary. Malad this your lordship will find from Rule 8A. Malad, your lordship will kindly come to the next page. A company, second paragraph, Rule 8A. Sorry, 8 is applicable, not 8A, Malad. 8 is every listed company, every other public company having a paid up share capital of 10 crore rupees or more shall have the whole time key managerial person. Now, the conclusion is, as per the record available, it's found that the company is a listed company. Further, it's also been also the company has not appointed any company secretary till date. Hence, the company and every director and key managerial person is in default of Section 203. And the penalty, Malad, kindly keeps this in note, Malad. Malad kindly sees, if any company makes any default in complying with the provisions of this section, such company shall be liable to a penalty of 5 lakh rupees, and every director and key managerial personnel of the company who is in default shall be liable to a penalty of 50,000 rupees, and where the defaulting is a continuing one with a further penalty of 1,000 rupees to the extent of not exceeding 5 lakhs. So this is the penal provision. Now, Malad, after issuance of this notice, Malad, I give a reply, Malad. Malad kindly takes page 29.
What is your prayer?
Sorry, Malad.
What is your
Malad,
prayer?
they have, Malad, the adjudicating authority and the appellate authority both have held that I should be penalized without, Malad, discussing these points which we have taken in reply to the show cause. So I am saying that, Malad, there's already an order in another matter, Malad, similar matter, Malad, where this court has set aside such orders and sent it back for reconsideration. So, Malad, I only want that they should also look into this, my reply, and deal with it. But my case before your lordship is violation of natural justice. So, Malad, I have come upon that saying that.
Show me the impugned order penalty.
Yes, Malad. Malad, first order, your lordship will kindly come to page 56. And this is the ROC's office, Malad. And will kindly come to, Malad, page 57 now. And I must put in a rider here also, Malad. Before this order, I'd already appointed the company secretary. I must just bring that to your lordship's notice. Now, the provisions are set out, Malad. Kindly comes to the second paragraph at the bottom of that page, Malad. As per the records available with this office, it has been found the company is a listed company. Further, is also observed company has not appointed company secretary in contravention of the provision section 203. Accordingly, the adjudicating officer has issued adjudicating notice dated 29th of September 2020, read with 203, read with Rule 3.2 of the company's adjudication of penalties, Rules 2014 as amended in Amendment Rules of 2019. To the company in default for the violation of the provisions of the Act, in para 1 and 2 above, Malad kindly keeps note of this, giving an opportunity to submit a reply as to why the penalty should not be imposed under the provisions of section 2035 of the Act against the company and its officers in default of the overstated violation. But why I'm Malad, putting some emphasis on this, because I consider, Malad, because this is the fourth round, Malad, fourth day of hearing, they have taken a point that there is no requirement of any hearing or any, Malad, adjudication. They are saying that it is there, therefore I have to apply that. No reasoning required to be given. And they have also relied on a judgment which we were supposed to consider. I've come with that, but I'm just keeping this.
No, but then an opportunity of hearing, you say, was not given to you.
Yes, Malad, it was given, but my points have not been considered. I'm just reading after that, Malad. I'm saying, Malad, why I'm referring to this is, if they are saying that it is automatic, then they shouldn't have issued a show cause notice.
All right, then the next
now
paragraph.
Can see, no adequate reply to the adjudicating notice as mentioned above in para 3 have been received from the notice. But I've shown your lordship that I've given a reply.
Where is your
Yes,
reply?
madam. Page 29, madam. 13th December 2022. Excuse me. Madam, kindly sees, madam, the second paragraph. But I say, madam, it is listed, but there is no work at the stock exchange, and there is really no work for a company secretary. But I'm still trying to find someone. Now, madam, this first.
Then paragraph 5.
Yes. Further, Mr. Dhal, authorized representative, attended physical hearing and the officer did not sought approval for the next date of hearing fixed on 15th December and was none appeared. Authorized appeared on 16th of November 2020, June, and the following order is reserved. So I make these submissions. Malad kindly sees now the order. The applicant company has officers who have defaulted the provisions for non-appointment of whole-time company secretary liable for penalties under section 2035. In exercise of the power, the undersigned is entrusted to adjudicate penalties under section 203 with effect from 2nd November 2018 upon consideration of the relaxation period of limitation due to COVID-19 pandemic.
All right, then this is passed on 3rd of August 23.
Yes, Malad, I prefer an appeal from that.
Yes.
Malad, the appellate order, your lordship will find at page 66. It starts at 65, Malad. The main portion is from 66. One will find at page 66, Malad, there is narration of what the appeal is about. Page 67, para 2, Malad. Again, Malad, it is held, Malad, para 2, second sentence.
Prior to that, you show me your grounds of appeal.
Yes, yes. Malad, kindly takes
61.
Malad, kindly takes, Malad, a page, Malad, it starts at 61.
Yes.
Malad, kindly sees, Malad, facts of the case are given below at page 62, Malad.
Where have you mentioned that the show cause reply was not considered?
Malad, dear lordship, Malad, this is the format. Now, grounds as such, I don't find there is any grounds. But your lordship, that would be evident from the order itself. If your lordship,
if you do not raise any ground, why will the authority consider that?
Malad, because Malad, your lordship will kindly see, I've raised the same grounds here at page 63.
Yes.
At page 63, if your lordship finds, these are the grounds. So even the adjudicating authority also does not refer to these. Malad, I am entitled to natural justice at every stage. Malad, your lordship is well aware of that. And the first stage I did not get. When I go in the appeal, Malad, the appellate court also says the same thing. That I have not given any reply. If lordship kindly takes
One minute. Yes.
Malad, your lordship will kindly take the provision once 203. Malad, they have given a reply, they have been heard. Now, what is the actual case, my lord? Your lordship will kindly take 203. We have no discretion. Admittedly, my lord, there has been a default. In fact,
he admits that there is a default. Only,
yes, he admits.
Only his
Now,
submission is that opportunity of hearing was not
Lord,
given.
that has been given to them. They have sent a reply and they admit that there's a default. We are looking for a suitable candidate.
Where is that considered in your order?
My lord, your lordship will kindly see at page 29 the reply which they give, my lord.
They admit it.
My lord. Second last line.
Yes.
However, we are hopeful of finding a suitable company secretary, my lord. My lord, now, your lordship will kindly take the provision of law. There is no discretion vested in us. Once there is a default, the sections trigger in, my lord. Your lordship will kindly take 203. What is the
203 has been quoted somewhere.
My lord, your lordship will kindly see the subsection 5, subsection 5 of 203. My lord, may I place this, my lord?
Before he places, my lord, if your lordship permits, my lord.
There is a similar order, you say?
Yes, that I would
Let
like
me see once.
Yes, my lord. My lord, your lordship will kindly see, my lord. This is the judgment in a similar matter. Chart ko chito. Chart ko dobo. Chart ko chito. Chart ko dobo. Diye dekta. My lord, this is in a similar facts, my lord. Your lordship will kindly see. Acha তোর কাছে আছে? আরেকটা আচ্ছা তোর কাছে আরেকটা দিয়ে Joshua Ache? Oh, I'm not. Oh, my lord, I think it was placed on the earlier occasion, my lord. But kindly comes, my lord, to page 2. And it is a clear finding of this honorable court, my lord, at page 2, my lord, somewhere in the middle, if your lordship kindly finds, upon a perusal of the language. Yeah, my lord has got,
Yes.
my lord. The said discretion also includes the converse. Well, sorry, upon perusal of the language of section 203, it is clear the same confers discretion on the ROC to impose penalty. Said discretion also includes the converse. That is the discretion not to impose penalty or to impose lesser penalty. The language of the section is that if any company makes a default in complying with the provision of the section, such company shall be, my lord, word has been liable to a penalty of the amount stipulated therein. Thus, payment of penalty is not mandatory. The liability to pay penalty is subject to adjudication by the concerned authority, that is the ROC. And may I just pause here for a moment? Well, they cannot say this now because they have themselves issued the show cause notice, asking for a show cause. If it was automatic, my lord, then they cannot ask for that. So they themselves also know that. Now, man, see, such discretion associated with it, a responsibility of the adjudicating authority to take into consideration any mitigating or elevating circumstances which might have visited the company in question before imposing such penalty and deciding the quantum. In the present case, several substantial elevating circumstances were placed before the ROC with the petitioner company by way of its representation. Although the representation has been substantially narrated in the order of the ROC, but this has not been done in our case. In the ordering portion thereof, it is found that the ROC mechanically observed the applicant company's officer have defaulted in the provision. Then, my lord, next paragraph. Apparently, the ROC also took into account the factors therein above and considered the relaxation period of limitation due to COVID-19. However, the ROC merely paid lip service to such consideration. There is no reflection as such in the order of the ROC of any material consideration of any of the factors which are portrayed by the petitioner as mitigating circumstances. Insofar as the appellate authority, that is the regional director, is concerned, the said authority mechanically affirmed the order of the ROC on the premises that no infirmity in the order of the ROC could be shown to the appellate authority. Such mode of the adjudication indicates non-application of mind on the part of the appellate authority, the facts and circumstances of the case while considering the imposition of penalty on the petitioner. Thus, in the absence of any real consideration worth the name of the mitigating circumstances of the petitioner company and the small size of the petitioner company, including that of its numbers of shareholders and share capital, as the fact that a whole-time compensation has already been appointed by the company since July 15, 2022, as functioning on the date of passing the impugned order. The impugned orders of the appellate authority as well as ROC appreciated for non-constitution of fact. Accordingly, it is allowed, setting aside the impugned order, and my lord, reconsideration has been sent for. Now, my lord, may I say this, my lord, this order has not been challenged. Now, this order is binding on my learned friend as a party. Now, they have never challenged it. As a matter of fact, I have taken information. This also, my lord, the notice has also been sent to the ROC by this company, my lord. Whatever it is, my lord, today, my lord, sorry.
Yes,
No,
yes.
I'm sorry, my lord. So, my lord, your lordship will kindly appreciate this becomes binding with regard to my learned friend. As a question of law, my lord, because one court has already held that there needs to be a consideration and there is no appeal from this. My lord, if your lordship permits, I know which judgment they're going to show. If I can refer to that and finish my arguments
Yes,
first.
yes, yes.
My lord, what they have relied upon. My lord, they have relied on, subject to correction, my lord. My lord, they have. My lord, they have. They have referred to 2006 5 Supreme Court cases 361. Now, this, your lordship will kindly see, also talks about the power of SEBI to impose penalty and whether that is can be challenged on the ground of violation of natural justice or is it automatic. Now, first thing, my lord, may I just, your lordship will kindly see the relevant paragraph and then I'll take your lordship to kindly please, my lord. That this order, my lord, if your lordship kindly sees, my lord, para 15 and 18, my lord. What is that? 15 and 18.
29, 35.
But 15, my lord, the statutory scheme has been discussed of SEBI. 18 also the statutory provisions. And then, my lord, they have referred to para 29 and 30. The tribunal set aside the order passed by the adjudicating officer on the penalty to be imposed for failure to perform a statutory obligation, a matter of discretion, which has to be exercised judicially on consideration of all the relevant facts and circumstances. Tribunal also held that the adjudicator has to be satisfied with the material placed before him that the violation deserves punishment. So this was what was said. And then, my lord, at para 30, it is settled now that when a penalty is imposed by an adjudicating officer, it is done so in the adjudicating proceeding and not by way of fine as a result of prosecution of an accused for commission of an offense in a criminal proceeding. In the instant case, the tribunal has failed to appreciate the respondents had given undue and unfair advantage to the associate brokers, which is detrimental to the interest of the unit holders. In the present case, and established by the adjudicating officer as well as admitted by the respondent, that there has been a conscious disregard of the obligation in as much as the respondents were aware they were acting in violation of the provisions of the regulations. As you know, after taking into account all the facts and of the case, imposed only a token of rupees 5 lakhs. So, there also, the considerations were there. Whether it was being violated intentionally or there was something which was required to be looked into, and that is what the Supreme Court holds. And not only that, this is in the domain of another act. With humility, I submit, today, we have a judgment of this Honorable Court on this rules, which has not been, your Lordship knows, has not been appealed against. So therefore, this judgment becomes binding on my learned friends and also on me, because that will be the law till it is set aside. So today, having not challenged, and now their references on this, that is what I'm just trying to point out to your Lordships. At page para 32, the mens rea question was dealt with. Kindly see. It says this court in a catena of judgments, para 33, has held that mens rea is not an essential element for imposing penalty for breach of civil obligations. And then discusses several laws, and kindly comes to para 35. In our considered opinion, penalty is attracted as soon as the contravention of the statutory obligation contemplated by the Act and the regulation is established, and hence the intention of the parties committing such violation becomes wholly irrelevant. A breach of civil obligation which attracts penalty in the nature of fine under the provisions of the Act, the regulation would immediately attract the levy of penalty, irrespective of the fact whether contravention was made by the defaulter with guilty intention or not. We also further held that unless the language of the statute indicates the need to establish the presence of mens rea, wholly unnecessary to ascertain whether such a violation was intentional or not. That is not our case. Our case is that, even Justice Bhattacharya also says the same thing, that there is a provision for lowering and giving a higher penalty. And since you have called for that why you shall not be held in violation, there you have to consider the reasons which I have given. So, there the word is shall be liable, and it has been interpreted that you will have to give a reasoning. Which, admittedly, your Lordship will see both the orders. There is no mention of what I have said. And I, at that moment, I had already appointed company secretary. They were appointed. So, today, this judgment on two grounds, one is the consideration in this case was of pure mens rea. But here the case is whether the reasons given can be accepted or not, which has not been in any way adjudicated by the authority. These are my submissions. If my learned friend wishes to take your Lordship to some other finding that, my lord, this order is not binding, my lord, then I would try and refer to some other judgments on the points of stay decisions if it's required, my lord.
My lord, your lordship will kindly take the statute once, my lord. Whether the ROC has any discretion in the matter or not, my lord. My lord, I'm
First of
referring to
all,
section
tell me
203.
whether
My lord.
the amount of penalty that
My lord.
is mentioned in subsection 5 of section
My lord.
203
My lord.
is it applicable in respect of any company, a big one, a small one,
Yes,
a
yes, yes. There's no
large?
discretion. And I will show from the amendment, my lord. The discretion was there earlier. In 2018, there was an amendment and the power was taken away.
And the figures are the same for all?
Yes, my lord, it is 1,000 rupees per day. So they have, my
So
lord.
that is a continuing
My lord,
offense.
figure is same for all. Absolutely, my lord. There is no discretion, my
There
lord.
is no scope for a
There is
lesser
no scope.
punishment.
No, that is why I wanted to place the act, my lord, before lordship once. Lordship will kindly consider section 203(5) once, my lord. What is my scope? Because if I do something which is not permissible under the statute, then that is an illegal order, my lord. I am bound to follow the statute, my lord. And it is
What
not,
was the requirement of issuance of the show cause notice?
my lord, because they did not have a company secretary, my lord. It's a
Yes.
listed company. Now, once your lordship will kindly take the section once, my lord.
Yes.
This was perhaps, my lord, section 203(5).
Hmm.
My lord, the point is whether there is, first point is whether there is any discretion vested in me or not, my lord, ROC. If any company, my lord, may I?
It is quoted in page 25.
Yes, it is
My lord,
quoted.
Yes.
203 subsection 5, my lord. That is important, my lord. That has not been quoted, my lord.
Yes, 25. If any company makes any default.
My lord, if any company makes any default in complying with the provisions of this section, such company shall be liable to a penalty of 5 lakh rupees. And every director and key managerial personnel of the company who is in default shall be liable to a penalty of 50,000 rupees. And where the default is a continuing one, with a further penalty of 1,000 rupees for each day after the first, during which such default continues, but not exceeding 5 lakhs. So, my lord, what has happened is in this case, although by calculating this, taking 50,000 and 1,000 rupees per day, the calculation comes to more than 7 lakhs. But because of the capping of 5 lakhs, it has been imposed as 5 lakhs on the managerial personnel, my lord. Now, if your lordship kindly sees, this question of discretion, my lord, this was there earlier. There's been an amendment in the year, my lord, 2018, with effect from 2018. Now, prior to the substitution, well, may I just place this, my lord? May I read? A copy. Now, towards the bottom, if your lordship kindly sees the amendment which happened, 88, right hand side bottom, my lord, substituted by the Companies Amendment Act 2019 with effect from 2/11/2018. Prior to its substitution, subsection 5 read as under. If a company contravenes the provisions of this section, the company shall be punishable with a fine which shall not be less than rupees 1 lakh, but which may extend to rupees 5 lakhs, which may extend. Your lordship will kindly see, now this may has been converted to shall. The discretion was there then, my lord, not today, my lord. This is my first humble submission, my lord. ROC has no discretion. He cannot overgo the statute, my lord. And every director and key managerial personnel of the company who is in default shall be liable to a penalty of rupees 50,000 rupees, and where the default is continuing on, with a further penalty of 1,000 rupees for each day, my lord, that is there. So, my lord, this discretion is no more there. The intent of the legislature is very clear. The discretion which was there earlier has been taken away, my lord. So, there is no discretion. Now, my lord, what does he say, my lord? In his application, he says, yes, he receives a show cause. My lord, show cause principles of natural justice is now inherent, my lord. I have to comply, my lord. Also because of judicial interpretations. And he admits, yes, there's a default. And in the ground, what he says, no person was willing to join my company. My lord, your lordship will kindly take this page 61. In the appeal, what he says, well, this is not a reason, my lord. And suddenly he finds a company secretary, my lord. Once this action is instituted, he finds a company secretary, my lord. Lordship will kindly take, my lord, in his memo of appeal, page 63. In the middle portion, I'm just quoting this, my lord. No qualified company secretaries are interested to be appointed in the company because there is no scope for career development. Like in a listed company with BSc Limited and NSC.
However, we have been able to appoint the company secretary on 2/1/2023 to comply with section 203. We are in the process of delisting the company from CSC. So, my lord, admittedly, there's a default. Admittedly, then he finds a company secretary. Now, the judgment of the Honorable Supreme Court, my lord, which we had relied, my lord. My lord, this judgment clearly states, my lord, when, well, may I draw your lordship's kind attention to paragraph 371. My lord, I am relying on this judgment because the moment there's a penalty, when there's a penalty clause, it triggers in, my lord, in case of default. Mens rea does not matter. Any reason for not having complied with the same does not matter. Now, the reason they have said is that no person was interested to join the company. This is no reason at all, my lord. Now, if your lordship kindly takes page 371, my lord, placetum B.
Yes.
In our opinion, my lord, this is around 8th line from the top, my lord. In our opinion, mens rea is not an essential ingredient for contravention of the provisions of a civil act. In our view, the penalty is attracted as soon as contravention of a statutory obligation as contemplated by the act is established, and therefore the intention of the parties committing such violation becomes immaterial. In other words, the breach of civil obligation which attracts penalty under the provisions of an act would immediately attract the levy of penalty, irrespective of the fact whether the contravention was made by the defaulter with guilty intention or not. This apart, unless the language of the statute clearly indicates the need to establish the element of mens rea, it is generally sufficient to prove that a default in complying with the statute has occurred. My lord, in this case, my lord, there is no discretion. Discretion which was earlier there has been taken away. My lordship will kindly see the impugned order of the ROC. My lord, what he says, my lord, in the order. May I place this order, my lord? My lord, he has no discretion. Penalty is envisaged in the statute, and it is only a question of computation, my lord. Your lordship will take page 59. Now, what my lord, if your lordship kindly sees, the number, the period is given there, the number of days, 788, 5 lakhs. So maximum penalty is 5 lakhs because of the statute, my lord. Otherwise, it would have gone to, my lord, 7,88,000 because of the capping. So this is a mathematical calculation, and he has no discretion, my lord. He has followed the statute. Now, if your lordship kindly takes the appeal, the order passed by the regional director, well, that is at page, my lord, 65. If your lordship kindly takes page 67, my lord, the calculation is set out. He sees this. Thereafter, paragraph 4 at page 68. It's only a matter of calculation, my lord. There's nothing else. Having considered the facts and circumstances of the case, and after taking into account the factors above, the adjudicating officer imposed a maximum penalty of 20 lakhs, rupees 5 lakhs on the company and rupees 5 lakhs on each of the 3 directors in default to failure make compliance of the act under section 203 of the act. He's applied his mind, my lord. He's revisited this. He finds no fault in this, my lord. And when there is none. Now, if your lordship kindly sees, my lord, paragraph B, my lord, at page 69. He says that the authorized representative had submitted a reference letter issued by the Calcutta Stock Exchange Limited to the appellant company, such as stating that the facts that the said company suspended from the records of the exchange. My lord, this is not a ground. This is the only point which he had argued, my lord. And then he finds the company secretary, he employs him, my lord, immediately, once the notice is issued to him, my lord. My lord, thereafter, paragraph 7, the undersigned by virtue of, my lord, then this is the enabling provision, my lord. And this is his order. It's a reasoned order, my lord. He applies his mind completely on the calculation. Now, if your lordship kindly sees Justice Bhattacharya's order, my lord. My lord, first of all, my lord, since my lord, this order has been passed, it is our, there have been some.
Nobody was there for the
Nobody was there for
respondents.
RC to, my lord. Nobody was there to respond, my lord. So, however, my lord, in this, if your lordship kindly sees page 2 of this order, the last 4 paragraphs, my lord, his lordship proceeds on the basis upon a perusal of the language of section 2035 of the Companies Act. It is clear that the same confers discretion on ROC to impose penalty. My lord, there's no discretion. The statute is very clear. Discretion which was earlier has been taken away, my lord. The said discretion also includes the converse, that is the discretion not to impose penalty or to impose lesser penalty. My lord, the judgment of the Honorable Supreme Court is clear. There is no discretion, no mens rea, nothing. If the statute imposes a penalty, it automatically follows. I cannot go into the reasoning of that, my lord, whether the reason is good or reason is bad. Once the statute mandates it, it has to follow, my lord. There's no discretion, my lord. My lord, there is no irregularity or illegality in the order passed, my lord. It is, my lord, the only question is calculation now. And it is an admitted fact there's a breach. Well, these are my respectful submissions.
What about preferring appeal from the order of Justice Bhattacharya?
My lord, that it has not been preferred, my lord. We are, my lord, if your lordship kindly considers the interpretation of law given by the Honorable Supreme Court, my lord, this judgment was also not placed before Honorable Justice Bhattacharya. This judgment is also not.
Anything in reply?
Yes. But I don't know whether, if we, because if we are holding
Yes,
it
please.
together, let
1
it.
minute, yes. Yes.
Then I can reply together.
The reason of Lord, after Sardas came, I am representing SFI. After Sardas came, Lord, it was found there serious breach by the companies. At least there are 1 lakh companies where they are defaulting, not following the rules of the law. Lord, companies were amended, and the rigorous provision was made, Lord, to penalize the companies. Now, in my case, company was incorporated in 1981. 40 years they didn't have a company secretary, and they are share broker. And they are saying this came in share market. Lord, they did the Canada establish share market. Lord, what is the reason of not appointing company secretary for 40 years, and how you can function? You are carrying on business.
And this provision for appointment of company secretary was there all along?
It was all through there. It was a limited company.
All right.
Private company. It is a limited company.
So this provision is all along there.
Yeah. There is no explanation why he didn't appoint a company secretary. There is no explanation in the writ petition. Now they reply that I did not appoint. No reply.
1 minute. 1 minute, please. Item 6. Let me see the file once.
Now, the companies, what they are doing, they know that I'll go to High Court, get the order, therefore don't apply. So,
Are there other orders also?
Not to my knowledge.
Then why do you say that they'll go to the High Court and get orders?
That is the feeling of the companies.
Feeling of the companies?
Complying to provisions. We have to strike out the name of the 1 lakh companies from the register.
On the same ground of non-appointment of company, not compliance. All right.
They are coming to NCLT, getting the order, filing appeal under 148. Now that is happening in the NCLT every day. There is no violation of principle of natural justice. There was a reply that I didn't appoint. Appeal was preferred. Appeal, kindly see the ground of appeal in my case. Kindly come to page 70. Not 70, kindly to page 70. What is the ground of appeal? Kindly page 70 start. Come to page 72.
Yes.
See the ground floor. Para 6. The company is engaged by both 3 directors, namely so and so. A price capital is 1 crore 30 lakh. Then C, my lord. Company is listed with the stock exchange only, and which is non-functional. It has become non-functional recently, not in 1981. It must be what is lord ground here, lord? I don't find any ground in the memo appeal. Just file the appeal and get the order. Not possible. You have to make a ground. And the allegation is that there is violation of principle of natural justice. There is total application of mind by the registrar company, by the RD, and they have dismissed the ground and now the penalty imposed as per the statute. There is no discretion to the ROC. I'm not, if you are not passing any interim order of stay, let them deposit the entire penalty in the court without penalty. If any order is passed by lordship. And secondly, the order passed by Bhattacharya is not binding upon your lordship. It is a single bench order. Single bench order. Appeal is not preferred. I don't know why the appeal is not preferred. But it's a single bench order. If my lord is not bound by that order. So in that lord, they will kindly not dismiss the petition here and now. Without any not showing any lord sympathy to the petition. The other topics are there, but it is identical as in item number 4. The appeal is there is reasoned order. It states that they have considered the reply.
it found inadequate. That is the finding of the appeal court, the ROC. In appeal court, there is no ground as such. 40 years you are running a company without company secretary. That means there is not a single explanation why it was not appointed company secretary. Just omitted. When the notice was issued, then you are appointing company secretary after you are caught. So that is what dispute commission will not dismiss the petition. In all three petitions.
Finished. But I'll stay this and binding effect of a single action of single court. But may I first deal with Mr. Tiwari's submissions? But first of all, Mr. Tiwari's submissions, I don't know whether he's really making that submission or he doesn't know about it.
Which one?
But this provision has come in the year 2018. He says 40 years have been without a company secretary. Your lordship will, with the book is with your lordship, Malad. 203(5) has been substituted by the Companies Act 2019 with effect from 2nd November 2018. So Mr. Tiwari suddenly makes a submission, Malad.
You will see the pre-amendment provision. There was provision for company secretary.
The mandate came here.
Came in
5 is the default, the penal provision.
Yes, now the rules, if your lordship sees the rules, rule 8A, Malad.
Yes.
That would be from 2014. Your lordship kindly sees
But the provision for appointment of company secretaryship was there.
But the mandatory provision and the penalty part, Malad.
Penalty comes later on.
Later. So the mandatory provision was not there. That is what I'm on. And that is why your lordship will also see.
Where is the provision for appointment of company secretary?
That your lordship will find.
203.
2031.
1.
Shall have the following. Class or classes shall have the following whole-time key managerial personnel.
Yes.
So, it comes, 2 is company secretary.
It comes into effect from 1st
2014. This is 2014. This is 2014. Now, the violation, and this is coming in 2018. So therefore, it becomes mandatory because there is a violation now, and it prescribes a penalty. So before 2019, Malad, therefore they also, Malad, if your lordship sees the period which they have calculated starts from 2018.
Because the penalty comes in later on.
So the violation also has been prescribed in 2018. So, Malad, what?
Till there is a violation or a penal clause, you are not required to.
No. And
mandatorily.
That is also their finding, Malad. That is why their notice is from 2018. What Mr. Tiwari is talking about, Malad, with humanity I submit, this is with regard to companies which did not file their returns. My company has been regularly filing returns. No dispute about that.
203, there is nothing with regard to filing of returns.
No, but what Mr. Tiwari made submissions, those are in respect of returns, Malad. Striking off of company happens only on failure of filing returns. Not, Malad, not appointing company secretary. Now, Malad, now with Mr. Kankani's submissions, Malad. Malad, he has not disputed 2 things, Malad, kindly appreciates. One, Malad,
yes,
that there is this order of justice, Pottajaju. You can't dispute that, obviously. Now, Malad, second, Malad, he was served notice. No dispute about that also. Third, Malad, he does not say that he is not aware of this order. As rightly, Malad, your lordship also asked him what about an appeal. Malad, he doesn't, obviously, he doesn't have instructions. Now, the fourth point, Malad, he refers to the Supreme Court judgment of SEBI. Malad, again, Malad, may I try and express myself? Mens rea, if it becomes a question, Malad, that would only lead to not imposing penalty or imposing penalty. If mens rea was read into it. Here the question is application of mind as to higher penalty or lower penalty.
Where is the scope of higher and lower?
Malad, that Justice Bhattacharya
has interpreted.
He has held. Shall be liable. And Malad, may I just point out, even in the Supreme Court judgment, Malad, kindly sees, Supreme Court talks about the mens rea, whether penalty should be applicable or not. That, if your lordship kindly takes the judgment, Malad, that is why I say, Malad, this will not have an effect, but it kindly comes to page 367.
Yes.
Kindly takes the last paragraph, placetum H. That included factors to be taken into account by the adjudicating authority with regard to the quantum of penalty. So there it was inbuilt. So the Supreme Court only held that penalty is a must. Their mens rea will not be taken into contention. Because mens rea means, my lord, if I did not have the intention, then no penalty. If I had the intention, then penalty. Now the question is on the quantum, my lord. That is what even Justice Bhattacharya has also held. That means shall be liable to what amount is required, my lord, from the face of it, my lord. Your lordship has seen the grounds that I have appointed in 2023, 2nd January. Even in their adjudication, your lordship will find they were adjudicated penalty till 16 June 2023. They were called informed. On the face of it, it does not reason. If your lordship kindly takes the petition once more. Now in the appellate court's order, excuse me. Your lordship will kindly see page 63. D. We have specified, that the company secretary has been appointed on 2nd January 2023. Your lordship has found that. Now, kindly sees his order. And he comes, at page 67, to the Office of the Registrar of Companies had issued adjudicating notice for violation of section 203 to the company's officers. In this regard, no adequate reply to the adjudication notice as mentioned above has been received from the notice. This is absolutely contrary to the records because I have given a letter reply.
No, he mentions no adequate reply. He doesn't say no reply.
But then he has to deal with it. Just by saying not adequate, why not adequate is the question. But your lordships have framed these questions. How natural justice has to be shown. At least one line. Then kindly sees 3, considering the above facts and circumstances. Kindly sees the duration for all of them. Check-ons, 1st September 2022 to 16 June 2023. Your lordship has seen that. He does not venture and say that no company secretary has been appointed. He doesn't say that. And I've also given the document of appointment. So absolute mechanical approach. The appellate court complete mechanical approach and the single, the ROC is also. And my lord will. Kindly, I don't know whether I need to show this, but my learned friend has taken this point with humility. I submit, that a single bench's judgment is not binding on your lordship. Coordinate bench judgment is binding, with humility. I submit, this I don't think but if your lordship wants me to refer,
Ex parte order, I don't know whether it is.
It is not an ex parte order because service.
Whether it was served to ROC.
That is the finding of his lordship, that's service.
Anyway, if you want to place it, you can.
Yes, Coordinate bench. will kindly take this, তোমরা তো বলে ফেলেছো তুমি ডিস্টিংগুইশ করতে নিশ্চয়ই যে জজ সাহেব অ্যালাউ করে অবভিয়াসলি আমার কি জজ সাহেব অ্যালাউ করবে না আমি কেন বলবো this is 2024 3 Supreme Court cases 224 and paragraph 1 the rule of judicial discipline and propriety and the doctrine of precedence has a merit of promoting certainty and consistency in judicial decisions, providing assurances to individuals as to the consequences of their actions. The constitutional benches of this court have time and again reiterated the rules emerging from judicial discipline. Accordingly, when a decision of coordinate bench of the same High Court is brought to the notice of the bench, it is to be respected as binding subject to the right of the bench of such co-equal forum to take a different view and refer the question to a larger bench. It is only the course of action open. So when it becomes binding, your lordship can definitely hold that I am not in support, and obviously your lordship can refer. But to say that it is not binding, my lord, with humility, I say that this may not be correct. And my lord, this point, on this subject, on this rule, my lord, they have not been able to show any judgment. So therefore, my lord, this, my lord, with humility, I submit, my lord, maybe, my lord, looked into your lordship, and my lord, I'm ready to go back, let them reconsider, my lord. So, my lord, these are my submissions, my lord. And in the event your lordship wants to hear further in the affidavit stage, then, my lord, I would seek for a stay, my lord. But I don't think, I think your lordship is going to.
Because there is hardly anything to
Absolutely, my lord.
file by way of affidavit.
No,
Whatever
there
is
isn't.
there is there on
Whether they need
records
to or they don't.
and the interpretation.
Absolutely, my lord. I bow down to your lordship, my lord. There is nothing less here.
Right.
Because, my lord, I have tried to show that is mechanical. Even that appellate order where I had taken the point that I've already appointed. How can they? Because it's not a continuing offense under that 203, my lord. Cannot be. My lord, these are my submissions, my lord. I'm sorry.
Would you like to show something else?
There cannot be a reply to a reply, my lord. I would not
Yes.
want. But, my lord, one thing, my lord, because my lord, Justice Prabhu Bhattacharya's judgment has been relied upon by them with regard to this same subject matter. But, my lord, I have one submission, my lord. The judgment which we have cited before, my lord, of the Honorable Supreme Court, 2006-5 SCC 23, was not considered by this judgment.
Yes.
That is what I am on.
Yes.
If it is not considered, because this is binding on with deepest of respect on my lord and even on the coordinate bench of my lord. So, my lord, in that circumstances, this cannot be relied upon. We have authority of Honorable Supreme Court.
No, we have said that this is not interpretation of that rules, my lord.
Not so far as not this binding with consumer. I have not learned that the judicial discipline, Lord. Your lordship may disagree with that.
Yes, I showed
may not send to the larger bench, but not binding by that.
No.
Other coordinate bench.
Submission made on behalf of all the parties.
And in the light of the Supreme Court judgment.
The judgment is reserved.
Obviously,
When Mr. Trivedi wants me to rush because I'm doing one of his personal matters. So he's asking me. I'm very grateful to your lordship.
Yes.
Well, all three matters, my lord. Very grateful to your lordship.
All three, same order. 4, 5, 6. একবার just rush করুন আমি দেখছি সব আলাদা অর্ডার হবে
I'm grateful, my lord. In my lord, please.
appearances নোট করে নিয়েছেন তো ঠিক আছে who is your other side 7
But I'm for the tribunal, but there's a private party who would be actually
the private party notice has been served. I am filing the affidavit of service, but they have their door was closed. It is as it appears from the track report.
Atlantic Projects. It's
Atlantic
a company.
Company.
CIT Road, maybe another attempt can be made.
Would you like to serve afresh? Is the company functional?
I don't have any.
Is the company functional?
Yes, my lord. The company is very much functional. I find from the track report that whenever the postal peon went there, they found the door is locked. There is.
Let me see the service.
Because this is the registered address. I believe the registered address is the best address. কি বলো না?
জানি না ওরা তো এটা ছিল MSME তে ছিল
It was a Saturday. The company possibly was closed.
If required, I can serve again.
Please come. The respondent number 3 is yet to receive a copy of the writ
in
petition.
our records, which your lordship will find at page 159, that email and everything is given. Maybe that can be.
Yes.
I can.
Soft copies you can serve.
I will serve everything.
159,
Actually.
the entire details of the company are given.
Let fresh service be made upon the respondent number 3. What is the issue about?
My lord, this issue is pertains to the MSME
Lord, I tell your lordship, Lord, there's a-
arbitration initiated under the MSME Act, my lord. My lord, there is an works contract. Works contract is very much outside the purview of the MSME authorities. My lord, that is the issue, and on that score, we have already in a similar matter, which is now pending before the Honorable Supreme Court, stay is there, and that matter is pending. I have brought the document also.
But the
Very
question
well.
is who will decide? Because the issue has now, Lord, your lordship knows under the MSME Act, under Section 18, the matter is, it went before the conciliation, the facilitation council. There was no settlement. It has been referred to arbitration. So this point should be taken by them
My lord, we have
before the
taken there.
tribunal in terms of Section 16.
My lord, we have
They took
taken
it at
there.
the point of conciliation. Conciliators have no power to
List,
decide.
list on 3rd of December.
3rd of December.
Affidavit of service filed in court is taken on record.
Item number 8.
This is my application.
How long
The
will it,
affidavit of service, madam.
how long will it take?
For the state led by Mr. T.M. Siddiqui, he engaged court number 11, your lordship.
Yes. Only not today. Tomorrow.
But let the matter retain its position.
Yes, it will be there.
Please, your lordship. This is the affidavit of service has been served, and my lord, even on the lawyers. My lord, same issue as
For the private
my lord,
respondent.
even for item number 7. My lord, this is a matter, my lord, where my section 16 has been rejected by the MSME Council in relation to a dispute pertaining to works contract. My lord, may I first,
1 minute. Who is for the
my lord, MSME Council.
rest for yes?
Miss Noel Banerjee is appearing for the MSME. She's on her way, your lordship. Let the petitioner start.
My lord, may I?
Today we are already running
My lord, I
late.
will just take 2 minutes. I'll just take 2 minutes because, my lord, this matter, this issue, my lord, Justice Shobbosatchi Bhattacharya held that a works contract is amenable to jurisdiction under MSME. MSME Council can determine. Section 18 of the Act says it is only related to goods delivered or supply or services. This matter, there are 6 judgments of several high courts which says no, works contract cannot be referred to MSME Council. So an appeal was preferred against Justice Bhattacharya's order before the Chief Justice, division bench presided by Chief Justice. Chief Justice stayed the matter. In the meantime, another matter, NBCC, my lord, I will just rely on that. NBCC's matter, my lord, which your lordship will find at page 704.
I'll take up the matter
My lord,
tomorrow. Tomorrow.
My lord,
We are
and
already
the
late.
matter has been, and
Yes.
Supreme Court has heard the matter, it's reserved for judgment.
So you want the matter to be adjourned?
I want only, my lord, the MSME Council should not proceed till the matter is decided by Supreme Court. It has been heard while the hearing was pending, the matter before MSME Council was stayed. It was stayed by the Supreme Court.
This is the submission not to take any
My lord,
steps till
my
the
lord,
judgment
kindly
is
take
delivered
page
by the Supreme
704,
Court.
NBCC.
I am yet to hear the matter on merits, so I do not know what it is.
Last day only I said, Lord, it's a point of law. The point is pending.
No, it has been heard, Ms. Banerjee.
No, that is what she is saying.
Petition has been submitted and matter is resolved.
Take
Judgment,
instructions.
yes.
Take instructions. Tomorrow.
Proceeding. Yes.
Tomorrow.
My lord, কালকের মধ্যে পারবি নোয়েল? কালকের মধ্যে পারবি? এই কালকের মধ্যে পারবি না সোমবার আসবি?
She's here. I'll just ask now. We are in my instructions were, we are not taking any steps.
Please come.
Your
Please come.
Lordship, I appear for the private respondent. Your Lordship,
Your lordship, my lord, Ms. Banerjee has said that she's not, my lord, can record the undertaking.
Learned advocate. No,
Undertaking, you can record a submission.
Learned advocate for the petitioner seeks a stay of the proceeding before the MSME Council in view of the fact that the issue is pending consideration before the Honorable Supreme Court.
Your Lordship, since a reasoned order has been passed by the council under section 16, I'm also challenging the maintainability of this writ. Your
Very well.
Lordship.
You are for the private respondent.
You are for the private respondent.
Learned advocate representing the private respondent raises an issue of maintainability of the writ petition. Stop. Paragraph. As it appears that now learned advocate representing the council admits pendency of the issue before the Honorable Supreme Court. Stop. As it appears that the issue is currently pending consideration before the Honorable Supreme Court, let the writ petition be delisted for the time being. Stop. The council, the representative of the council submits that no steps will be taken till judgment is delivered by the Honorable Supreme Court in this matter.
Grateful.
Affidavit of service is taken on record.
Yes, my lord, let it be disposed of. Let it be
Not
disposed
disposed
of.
Oh, my lord, if
No,
if the Supreme Court holds that the works order cannot be.
Stuff, not disposed of.
Lord, because they are saying that we do not have any jurisdiction. If today, my lord, Supreme Court says that yes, works contract has no jurisdiction, then I will have to, my lord, abide by that, and my lord, the proceedings will.
My lord, let the writ
The petition today before your lordship is only that question. It's the
What will you do if the writ petition is disposed of?
Your Lordship,
How does
let
it
the
come
Supreme
to your
Court order
benefit?
let the Supreme Court
How does it come to your benefit?
If it is disposed of, my lord, then it is.
Then what happens?
Sir, if it is kept also, my lord, nothing really
Then
happens.
I am
let
the
the Supreme
claimant before the
and
Presidential
she is
Council,
already
Lordship.
raising an issue of maintainability of the writ petition. How can it be disposed of in this manner?
I will then address that because what she's saying, my lord, is an order in conciliation that I have
Hmm.
passed.
No.
No,
Section
sir,
16.
16 of the arbitration.
They
Act.
filed the statement of claim. Grateful.
Original side is over.
Also, yeah,
It's a statutory body.
Court has no jurisdiction in our.
Grateful.
I appeal for the bank, for the respondents, number 1 and 2.
Why to be mentioned? Why to be mentioned, Jana Babu? Why to be mentioned? Personal appearance ছিল কার পার্সোনাল অ্যাপিয়ারেন্স ছিল? আপনি পিটিশনার? বলুন।
ম্যাডাম আমার ব্যাংক ডিএম সাহেবের একটা অর্ডার হয়েছে, সেই অনুযায়ী আমি টাকা নিয়ে ঘুরছি, কিন্তু ব্যাংক সেটা নিচ্ছে না।
কোথায় অর্ডার হয়েছে?
22 নম্বর পেজে।
আপনি কি বাড়ির মালিক?
ফ্ল্যাটের মধ্যে
কত টাকা লোন নিয়েছিলেন?
14 লাখ টাকা।
Where are the figures appearing? Will you please show me?
Yes, but the figures, if your lordship sees the possession notice at page 21. This is also there in the 32 notice, which is page 14. There, my lord, the loan, the amount of the loan was 13,52,000. Page 15, if your lordship sees, paragraph 3. Total outstanding.
Page 21 you showed me.
Yes, that's the possession
notice.
Yes.
1352.
1352 as on 8th May 2019.
Right.
Yes, my lord. Now, my lord, what has happened? The
Description is one self-styled, tile floored flat, 4th floor, super built area 942 square feet.
Yes.
Petitioner is the owner.
Petitioner is the owner.
You've taken symbolic possession?
Well, no, but the police, the payments have been made to the police, and the symbolic possession is required to be taken.
How much have you received?
No, actual possession. Actual physical possession has not been taken pursuant to the district magistrate's order. But when a symbolic possession, as regards when the possession notice has been given, symbolic possession has been taken. But when after the Section 14 order was passed, we have to incur certain expenses for the police. But that we have paid. Now it is in process. But in the writ petition, what the petitioner is saying that
Did the petitioner approach DRT?
Yes, that is the point of maintainability. Ma'am.
Did
At
he
the very
approach?
No.
He didn't.
No appeal from this order.
Right. Now, is he paying something to y'all?
Well, what he has offered, that offer has already been rejected. Well, what he
Yes.
has offered was, that's at page 24. Well, he is offering the amount which was due. That was the total outstanding back in 2019. But now, 5 years have gone by, interest has accrued, but we have rejected his offer, which is at page 29.
1352 he is offering now.
Yes. That's the amount which was outstanding when we issued the notice under 13.2.
I understand. 1352 he is offering
Yes,
now.
that he is offering. 5 years have gone by. We have
Yes.
rejected his
What
proposal.
will you do? You'll auction the property, isn't
Yes,
it?
we will auction the property.
And,
After taking possession, we will auction the property.
Right. Now, if he puts in the money to you and he is willing to pay the interest, then would you still
Malad, as on this date, the due is 29,56,000. He's offering less than a half of it. Without going into the question of maintainability, since he's appearing
residential flat?
yes, that is why.
Otherwise, the court would not have entertained at all.
I appreciate. But what I can do, if the petitioner pays off this amount,
29.
that is the outstanding.
All right. ব্যাংকের বক্তব্য হচ্ছে 29 লক্ষ টাকার কাছাকাছি ডিউ আছে। আপনি 13,52,000 কিছু এরকম দেওয়ার বলছেন।
হুজুর, ডিএম সাহেবের অর্ডার করেছেন 10 জুলাই। আমি অর্ডারটা হাতে পেয়েছি 8 সেপ্টেম্বর, প্রায় 56 দিন বাদে।
এই অর্ডারটা 6 মাস সময় আছে এক্সিকিউট করার জন্য।
আমি এই অর্ডারের টাকাটা পুরোটাই জোগাড় করেছি, 5 লক্ষ টাকা ডাব নিয়ে ঘুরছি, পাঠিয়েছিলাম ব্যাংকে চিঠি
5 লক্ষ?
5 লক্ষ টাকা 3টে কিস্তিতে বলেছিলাম।
আচ্ছা।
অক্টোবর, নভেম্বর, ডিসেম্বর 5 লক্ষ টাকা ওরা বলেছিল দিতে, আমি সঙ্গে সঙ্গে পাঠিয়ে দিয়েছি। 26 নয় হুজুর, আপনি এটা দেখুন, আমার এই 26 নম্বর পেজে
5 লক্ষ টাকা করে 3টে ড্রাফট।
না, 5 লক্ষ, 4 লক্ষ, 4 লক্ষ,
মানে সব শুদ্ধ 13,52,000। কিন্তু এই টাকাটা তো বাকি ছিল 2019 সালে, এখন 24 সাল চলছে, তাহলে ইন্টারেস্ট কিছু বেড়ে গেছে।
কিন্তু হুজুর 24 সালে 10ই জুলাই এই অর্ডারটা কিন্তু হয়েছে।
আপনি দেখুন 10ই জুলাই যে অর্ডারটা করেছে তাতে লেখা আছে 13 লাখ টাকা ডিউ ছিল 19 সালে, বলেনি কিন্তু 24 সালে 13 লাখ টাকা ডিউ আছে। বুঝতে পেরেছেন? এটা বলছে 19 সাল পর্যন্ত এটা বাকি ছিল।
তাহলে
আপনার ইন্টারেস্ট তো বাড়তেই থাকছে।
কিন্তু
ব্যাংক এখন এটাকে অকশনে বিক্রি করবে। এবার আপনি কি করবেন? আপনার নিয়ম অনুযায়ী আপনাকে ডিআরটি দিতে হবে।
ডিপার্টমেন্ট থেকে বলছে কখনো 16 লাখ টাকা, লাস্টে নেমেছে 14 লাখ টাকা।
কোন ডিপার্টমেন্ট কি বললো সেটা কোর্টের জানা নেই। এখানে উকিল বাবু আছে, উকিল বাবু বলছেন যে 29 লাখ টাকা ডিউ আছে।
29 লক্ষ টাকা হুজুর দেওয়ার,
সেটা আমার পক্ষে এখানে বিচার করা সম্ভব না। এটা ব্যাংকের টাকা, ব্যাংক বিচার করবেন যে কত নেবে না নেবে।
ডিএম যে সাহেবের রিপোর্টে তো যে টাকাটা, সেই অ্যামাউন্টটা আমি দিতে পুরোপুরি রাজি আছি।
কোথায় আছে বলুন তো? ডিএম সাহেবের রিপোর্টে পড়ুন তো কোথায় আছে। 13 লাখ টাকা যেটা বলছেন সেটা কোথায় আছে দেখান। বলুন কোথায় আছে, আপনি পড়েছেন? কে বলেছে আপনাকে ডিএম সাহেবের এখানে এই টাকাটা বলা আছে? কেউ বলেছে তো আপনাকে?
হ্যাঁ।
কে বলেছে?
আমাকে যে উকিলবাবু একটু করছেন তিনি বলেছেন।
যে উকিলবাবু বলেছে সে উকিলবাবু আপনাকে ঠিক বলেননি। যিনি বলেছেন উনি অর্ধেক কথা বলেছেন আর অর্ধেক কথা বলেননি। টাকাটা বলেছে ঠিকই, কিন্তু সেটা ডিউ ছিল 19 সাল পর্যন্ত। বুঝতে পেরেছেন? এবার আপনি কি করবেন সেটা আপনি,
কি করব বলুন?
আমি জানি না কি করবেন। ব্যাংকের টাকা,
কেন অর্ডারটা স্যার
24 সালে কেন হলো সেটা আপনি ডিআরটি তে যান, আমি আপনাকে ডিআরটি তে পাঠিয়ে দিচ্ছি, আপনি সেখানে চলে যান, ঠিক আছে? তাতে কিন্তু আপনি ব্যাংক কিন্তু থেমে থাকবে না, ব্যাংক কিন্তু তার কাজ করে যাবে। কি বুঝছেন? How much can you?
But I'll have to take instruction.
Yes.
But
আর কটা বাড়ি আছে আপনার?
আর কোথাও নেই।
কোথাও বাড়ি নেই?
Malad, as it appears, Malad, the secured there are two secured properties. Malad, if your lordship sees the 13-2 notice, page 17 is the schedule to the 13-2 notice. Page 17, Malad, what is one is a land and another one is a self-contained flat, which Malad, perhaps the petitioner resides in. There are two properties, and Malad, the section 14 order has been passed. In
1 minute, one that piece and parcel of land is 5 cutters, 33 chitaks, more or less along with a G+4 story building. Possibly this flat is in this property.
Malad, yes, Malad, perhaps, but Malad, even
But then he does apart from this flat, he doesn't have anything. It does not mean that the entire G+4 story building is mortgaged to you.
that is what is recorded in the schedule of even in the DM's order. Your lordship sees page 22, schedule of the property. Lordship will kindly have a note. Page 22, lordship has.
22.
Page 22 is the section 14 order. Your lordship has the schedule of property, serial number 1, where the property is described.
I can see it is described, but whether it is the same premises number 21, name and identified as Milon.
Aguyati first line address appears to be the same.
Yes, it's the same address.
Address appears to be the same, but perhaps it may also be the land as well as the flat. I'll have to take clarification on that.
When it is a flat, you have the corresponding land also there, but it does not mean that the 5 cutters, 36 chitaks and
I don't think so. I don't.
No, it is not. It's this only 924 42 square feet.
Yes.
Super built.
Yes. Yes, that's
Then?
it. But I'm not saying anything on that. But if the petitioner can at least offer a reasonable amount, I can take instruction. If less than a half, I cannot even ask.
No, he goes till 1352. He has been able to.
He wants to. He wants to pay.
He has been able to obtain drafts also for this amount.
He has offered us 5 lakh. He's saying that he's willing to, or he can pay us 1352. That is less than half.
Would you give him a hearing and come up with some positive instruction?
You can do that, my lord. Lordship, instead of that, kindly keeps it tomorrow. I'll take instruction from the bank, and my lord, we'll come back tomorrow. Whether we can have a hearing held and he can again offer something, then we can.
Then day after tomorrow.
Very well, my lord. Day after tomorrow.
Please come.
Keeps the point of maintainability open.
The residential flat of the petitioner having super built area of 942 square feet.
Lord, may I have a lordship's leave? Great. My colleague is here.
Have been directed to be taken physical possession as the petitioner failed to pay off the dues of the loan which was taken. Stop. A sum of rupees 13,52,238,66 was due and payable by the petitioner on 8th May 2019 when the notice under section 13 within bracket 2 of the Surfacy Act 2002 was issued. Stop. The District Magistrate, North 24 Parganas has passed order on 10th July 2024, allegedly received by the petitioner in September 2024. Intimating that physical possession of the property would be taken. Stop. Paragraph. The petitioner has rushed to this court by mentioning that he is agreeable to pay off the dues of rupees 13 lakh and odd. But the bank is refusing to accept the same. Paragraph. Learned advocate representing the bank raises objection with regard to the maintainability of the writ petition. Stop. It has been submitted that as on date, nearly 29 lakh and odd is due and payable by the petitioner. Stop. Paragraph. The petitioner has expressed his inability to pay the total due in one go. Stop. He seeks installment. Stop. Learned advocate representing the bank is directed to take instruction with regard to the take instruction as to whether petitioner may be offered any further time for paying off the dues. Stop. List 22nd. Service is taken on record. তাহলে petitioners করবেন লোন কজন নিয়েছিল? দুজনে মিলে একজন গ্যারান্টার আছে নিশ্চয়ই, পিটিশনার্স করে দেবে। এই রিট পিটিশনটা কে তৈরি করে দিয়েছে আপনাকে?
ওই ব্যারাকপুরের বাবুর,
ব্যারাকপুরের উকিল বাবু?
ব্যারাকপুরের একজন উকিল বাবু।
তো উনি এখানে এলেন না কেন?
উনি আমাকে বলেছে আমি এসছেন, আমি এগুলো করে দেবো, আপনি একটুখানি বলুন। আর আপনি তো টাকা দিতে চাইছেন।
আর ঠিক আছে, কাল বাদ পরশু মামলাটা আরেকবার হবে। ব্যাংকের উকিলবাবু খোঁজ নিয়ে আসবেন যে আপনি যে টাকাটা অফার করছেন সেটা ব্যাংক নেবে কি নেবে না। যদি নিল তাহলে ঠিক আছে, যদি না নেয় তাহলে আমি জানি না আপনি কি করবেন।
For the state respondent, my lordship.
আরেকটা এখানে ফটোগ্রাফস আছে, সেটা ফটোগ্রাফ হবে।
For the state respondent.
Lordship, I'm appearing on behalf of the petitioner. I'm led by Mr. Deepan Kumar Sarkar. He's currently in legs of court number 38. I'm seeking for a short passover. Lordship, he will be here.
Shiva, you appear for the respondent bank. This matter has appeared for extension of interim order There was an interim order passed by the London Coordinate Bench, my lord. Now, this is with regard to the 13.2, it is in between 13.3 and 13.4. Now, my lord, in respect of this injunction, my lord, we cannot proceed. Now, they were given directed to accept, my lord, come before the bank for a settlement. They offered the time, my lord, time was granted 10 days from that date. On the last day, they appeared at the bank just before the puja vacation.
My lord, kindly seize your lordship, whatever.
1 minute, 1 minute.
Now, my lord, they have approached the bank with a certain offer.
Yes.
Now, my lord, bank is yet to accept, my lord, bank have requested them to provide their financials, the balance sheet and all those things. My lord, 5 crores an order due.
Lordship,
My lord, we require some more time to get all those, my lord, details from them, and
Very
thereafter we can come back to your lordship.
Very well. Please come. It has been submitted by the learned advocate representing the bank that the petitioner approached the court on the 10th day of the order passed on 7th October 2024. Stop. The bank is yet to take a decision in the matter. Stop. Paragraph. In view of such submission, the interim order passed by the court on 7th October 2024 is extended till 20th of December 2024. Stop. Let the matter appear in the list on 10th of December.
So yesterday night at 10:30, they gave some more documents.
Learned advocate representing the parties shall come ready with all necessary instruction on the adjourned date.
I'm grateful.
I'm so grateful to you.
Lord, on the adjourned date, my lord, if it could give some precedence, my lord.
10th?
10th, not the adjourned date. If my lord, I get some precedence, so the matter
Yes,
can be
yes.
out.
The matter will be taken up.
I'm great.
But I appear for a very short matter. Lord, the United Spirits, Lord, has Lord 3 units where Lord they produce Lord the liquor. Lord, what they do is they manufacture Lord foreign liquor by bringing in Lord the industrial alcohol. Then Lord they convert that. Now, in the process of Lord manufacturing, certain spirits, my lord, they are impure, they're called impure spirit, that as in industrial alcohol, they are waste spirit. Now, my lord, we are not being permitted to, Lord, destroy this waste spirit. In fact, in respect of 2 of the units, earlier there was a demand raised, which was set at rest by a division bench judgment. If your lordships, my lord, kindly see the division bench judgment at page 48. This is kindly see the second volume. I don't.
Second volume.
ওইখানেই হবে দেখুন ছোট 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 ভলিউম আছে
Oh, this is the volume is here. Yes.
Lord, page 48 it starts. Kindly Lord come to page 74 first. There was a demand raised with regard to the destruction of this liquor. Actually, Lord, they had asked for sale of this liquor to any licensed vendor, which the state said that you have to pay a certain amount. That was the subject matter of challenge. Your lordships may kindly take the second paragraph. In the case before us, clause 1, etc. of section 86 Bengal Excise Act, power to the state government to make rules relating to prevention of wastage in the process of distillation by imposing various restrictions, but in the process no power has been given in that section or any other section or the act to levy any amount for payment upon manufacturer for enforcing those regulatory measures preventing wastage except the provisions of penalty contained in section 54A, nor is there any power conferred by the act to impose any levy or any fee of duty for enforcing preventive measures of wastage. Whereas for enforcing the measures prescribed in clause 7 of section 87, which fall within the taxing power of state, the legislature has given explicit power to impose fees at different rates as appearing in expansion 1 to the said section.
Such power is conspicuously absent in the case of enforcement of measures provided in clause 1, 2, and 9 of that section. On the other hand, section 54A of the Act gives specific power of imposition of fine not exceeding 5,000 in case of violation of any rules made in pursuance of the power conferred under section 86 of the Act. Then, Lord, the other discussions are there. Kindly come to page 77, the ultimate finding. We therefore hold that sub-rule 4 of 14A, framed in exercise of power, police power of the state conferred under clause such and such, authorizing imposition of duty on wastage in the process of distillation at par with the highest rate of duty payable on IMFL, is ultra vires the said statute itself, and thus is liable to be struck down on that ground alone. We, however, do not dispute the power of the state to impose other regulatory measures prescribed under Rule 14A, except imposition of duty prescribed therein. In the absence of conferment of such power in the Act, and state would be free to enforce those regulatory measures. The writ application therefore succeeds. Let there be a declaration in terms of prayer A and C. Now, Lord, the matter goes to the Supreme Court. Supreme Court has only issued a notice. There is no stay of this judgment. But, Lord, in the meantime, in respect of those two units, there were applications filed before the Supreme Court because they were the subject matter, Lord, of the special petition and the civil appeal now, where, Lord, the Supreme Court gave liberty to destroy this spirit, this industrial alcohol,
Without payment of any charges.
Because, Lord, the finding of the High Court of the division bench
Yes.
is that, Lord, there is no taxing power because they are trying to charge the highest rate of duty, which the division bench held that they don't have that power. They have a regulatory power, but in course of regulatory power, they have no power to impose any fee or any duty in terms of the statute. That is an issue, Lord, which is pending in the Supreme Court. May I just place the order at page 79? There are 2-3 orders, Lord, which I want to place. 79. Kindly, Lord, come to page 79. It says it is agreed that the spirit at Bhadrakali and Srirampur. There are 3 units. One is Bhadrakali, one is Srirampur, and the other is Asansol. We are concerned with Asansol now. Bhadrakali and Srirampur has to be disposed. Let CGM Hooghly, West Bengal be present there and submit a report to this court about the quantum of impure spirit destroyed in his presence. Then, Lord, the next order, there was an application filed for recall of the order because, Lord, we wanted to sell this industrial alcohol as industrial alcohol. That was not permitted, Lord, by the Supreme Court. It says we find no ground to recall the order. The application for sale is hereby dismissed. Let the order
So
pass
this
by
impure spirit can be sold as
industrial alcohol. Because, Lord, for this varnish or, Lord, this what do I say? The carpenters, Lord, they take these oil.
All right.
And, Lord, also, Lord, there are some other usage. There's a restricted usage, but they are all license holders. But that was not permitted by the Supreme Court. We are not getting into it at all. Lord, please come to page 81, where they say the IA number such and such, the issue concerning destruction of impure spirit was considered by this court, and the Chief Judicial Magistrate Hooghly was directed to be present at the stage of cause of destruction and submit a report about the quantum of impure spirit destroyed in his presence. The order has still not been complied with. Then ultimately, Lord, this order was complied with. Kindly see page 82. It says in continuation, kindly see the second paragraph. In continuation of the order dated 18 December 2019 passed by this court, we direct CGM Hooghly, West Bengal to depute an officer from his court who shall personally supervise the destruction of impure spirit under the guidance of CGM. The CGM is at liberty to alter or modify the schedule drawn up, etc. Because obviously, my Lord, CGM could not have been present personally. Therefore, my Lord, this modification was allowed.
116 working days were required to cause destruction of the impure spirit.
Yes.
In
Lord,
one day, how much can be destroyed?
In one day?
Yes.
How much? No, how you see?
Anyway,
your
whatever.
I'll tell you, Lordship, Lord, this is, so far as this impure spirit is concerned, please see page 83. After that order of the Supreme Court, we apply to the Deputy Excise Collector. Your Lordships will find that. And we say that, Lord, page, kindly come to page 84. I think that's the type copy. 19th May. Page 84. That's the type copy. Kindly see the third paragraph. In this regard, as informed earlier, there is approximately 3,51,948 bulk liter of unutilized spirit, impure spirit, which is currently lying at the unit. Unfortunately, the stock of impure spirit is no longer capable of being used in the manufacturing process and not to be sold in the open market. Hence, the only available option is to dispose of the impure spirit at the earliest. Your good self would appreciate that the storing impure spirit at the unit is dangerous, detrimental to public health. The impure spirit is hazardous in nature, etc. Even from the perspective of pollution control, it is not at all suitable. Then, Lord, we sought permission, and the reply is at page 86. They say that you get a court order.
They did not specify any charges or anything of that sort.
Lord, there can't be any charges.
Because of the division bench's order?
Yes, number one. And number two, Lord, this is industrial alcohol.
Yes.
Lord, the state does not have any power to impose any tax or fee in respect of the industrial alcohol, so long it is not, Lord, converted for consumption. In the moment, Lord, the
Consumption means human consumption.
human consumption. Human consumption. Industrial alcohol is not within the purview of the state. That is what the division bench judgment is.
Anyway, do you have any objection?
No, my lord. My lord, only thing is that, my lord, ultimately the issue is pending before the Honorable Supreme Court. Ultimately, if the Supreme Court says it is intra vires, kindly protect our right that we can subsequently raise our demands.
It will be subject to the result of the
final result.
subject to the outcome. Yes, of course.
It is ultra vires, but as an if Supreme Court subsequently intra vires, it would be a retrospective. Knows.
Lord, kindly make it clear that it is subject to the outcome of the result of the pending litigation in the Supreme Court.
And this has to be done under the supervision of the CJM again?
Yes,
or any officer from the...
Has to be.
Collector can. Lord, if the collector can.
What does the legal provision say? Is it to be done in the present?
I have not come across any.
There is no provision.
What happens is, Lord, it is accumulated over a period of time since
Right.
2014. But normally what happens is that, Lord, small quantities, that permission is sought and that is destroyed. That is how it used to be.
How much is there in your
That is,
go down or factory?
Yes, kindly come to, Lord, that page 84.
My lord, I have a report. My lord, I have a
Please
report.
give.
My lord, I have a report to this extent.
3,51,000.
Because, my lord, with time, my lord, it gets depleted. With time, the original when the paper is
351,948.
Yes.
This is the figure.
948.
Page.
Lord, in the process, from the time the application is filed and, Lord, the matter is being heard, there may be some more accumulation.
My lord, kindly see the first my report, my lord, the physical stock that was taken in year 2009, because it is lying from 2009. It was so.
Lord, whatever the situation
as
is,
on that date, my lord, the demand would be made. That's why, my lord, I had asked for the file a report, because on 2009 it is lying. So as on that date, if ultimately the
On and from date, not
on
as on that date, but on and from date, the demand.
Yes, my lord, on and from that.
Lord, this is the issue that is pending before the Supreme
So
Court.
if
So, Lord, once the Supreme Court decides this issue,
Then the date from when it will be effective.
That will be a separate. But Lord, I tell your Lordship, I am before the Supreme Court. I am myself before the Supreme Court in respect of the 2 units. If the imposition is there with regard to 2 units, imposition will also be there with regard to the 3rd unit. So that is why I am saying, kindly make it, Lord, subject to the outcome of the result.
only with deepest respect, in the division bench also said the state has the power. That is why I can show Mr. Khaitan has given a consent also that state has the power.
Whatever. Without going into all these things.
Sir,
Please come.
State Mr. Khaitan বলেছে এখানে power আছে।
The petitioner applied before the excise commissioner
They have not gone into
seeking permission to dispose of
bench to decide.
impure spirit. Page 84 এ দেখবেন FEINT SPAIRIT এটা ব্র্যাকেটে দিয়ে দেবেন from its premises.
That is
Stop. The senior joint commissioner of excise by a communication dated 24th of August 2023.
Sorry. কাকে ডেপিউট কাউকে একটা ডেপিউট করে
Not mentioned, advised the petitioner to proceed to seek a suitable order from the appropriate forum of law for disposal of its prayer. Paragraph. The communication of the Senior Joint Commissioner mentions about a proceeding which is pending before the Honorable Supreme Court in the case of State of West Bengal and others versus Shaw Wallace Distilleries Limited and another in CA number 8290/2013. Stop. Paragraph.
But instead of Shawales, it will be United Spirits Limited. That name has changed from Shawales.
Page 86 mentions
Yes.
that name. That is the reason I have mentioned.
Because my lord, United Spirits is the applicant before your lordship, and that is because there is a change of name.
Learned Senior Counsel representing the petitioner submits that the spirit
Record the correct one here.
is the spirit cannot be used for any purpose at this stage, and the same is required to be destroyed. Stop. Paragraph. Learned Advocate representing the State respondents relies upon the instruction forwarded by the Deputy Commissioner within bracket revenue and Deputy Excise Collector in charge of USL, Asansol, signed on 2nd November 2024, mentions that the physical stock of head cut spirit / faint spirit lying in the distillery of the petitioner at Asansol as on 31st of March 2009 was 4,18,882.8 LPL / 2,75,744 BL.
কত হয়েছে তো এখন তাই আছে তখন তাই কারেন্ট স্টক তাই 393 আছে তখন ধরতে হবে যেটা ডিস্ট্রাকশন হবে 393 আছে না এটা হবে এখন মানে ডিউটি
The current stock of faint spirit lying in the distillery unit is 3,93,780.44 LPL / 2,88,137.0 BL as inspected on 1st November 2024.
একটা পার লিটার
Stop. Paragraph.
বাল্ক লিটার বিএলটা হচ্ছে পার লিটার
Whether any fees will be leviable for destruction of the said spirit. Now, the issue, whether a jaiga, the issue, whether any fee will be, is pending consideration before the Honorable Supreme Court.
But may I just tell your lordship, it's not lord for destruction.
For
whether fee or tax is leviable on this industrial alcohol as a regulatory measure by the state.
For use of this alcohol.
For the whether any levy can be made by the state. Issue is whether any levy can be made by the state on this waste alcohol.
On the waste alcohol is pending consideration.
Utilize cut spirit, which is of
before the Honorable Supreme Court. Stop. Paragraph. It is admitted by the parties that the spirit cannot be consumed at this stage and is required to be destroyed. Stop. Next. The Honorable Supreme Court, in the pending proceeding, permitted the impure spirit to be destroyed
In respect of Bhadrakali and
in
Srirampur unit.
respect of the Bhadrakali and Srirampur unit. Stop. Similar prayer has been made in respect of the Asansol unit in the present writ petition. Stop. Paragraph. In view of the above, the instant writ petition is disposed of by permitting the petitioner to destroy the impure spirit under the guidance of the concerned Chief Judicial Magistrate and in the presence of any of the officers of his court. Any of the officer of his court. Officers of an officer of his court. Stop.
কত সময় লাগবে?
It will be open for the Chief Judicial Magistrate to fix up a schedule according to which the work of destruction of impure spirit will be done. Stop. Next.
from his court, not from this court.
From his court, তাই বলেছে। তাই বলেছে।
A report shall be forwarded to the Deputy Commissioner within bracket revenue or to the Commissioner who
The
should
Commissioner of Excise.
to the Commissioner of Excise
With a copy to us, Lord.
with a copy forwarded to the petitioner. Stop. Anything else to be recorded?
But as regard to kindly protect the revenue as regard to the demand, as regard.
Apart from that, any steps taken? No, the steps taken. No, the issue of levy of tax shall abide by the result of the pending proceeding before the Honorable Supreme Court.
Tax or fee, Lord.
Tax/fee.
And Lord, kindly fix an outer limit for the purpose of Lord completing
The quantity is such, I do not know.
That is true, Lord. Technically, I also would not be able to assist your Lordship, Lord.
30 days.
Huh?
30 days.
Instruction is that it can be done in 30 days. Give 6 months. Kindly give 6 months. I can't vouch for the time, Lord.
Before the Supreme Court, it was 116 working days. 116
So that
working
quantity
days.
must have been more, Lord, because 2 units were in.
Yes.
So here, kindly give 6 months.
Acha. The learned Chief Judicial Magistrate shall ensure that the destruction is completed within a period of 6 months from the date of communication of this order.
Much. I am for the petitioner, ma'am.
I am appearing for the response number 4. Officer in charge.
My for CS.
সার্ভিস দিতে হবে এগুলো একসাথে সেলাই করে দাও I am for the petition in this matter, madam.
I am for the response number 4.
I deposited the
Respondent number 4.
My for CSC.
Respondent number? 11.
But a matter pertaining to, my lord, new connection, electricity connection.
1 minute. Respondent number 11 is here. 4 is here.
I'm for CSC.
State.
And
You're for
5 to-
CSC. What about 5 to
5
the
to
10?
The this is the return, my lord, with the endorsement refused. Refused and 1 and 2 unknown.
1 and 2.
1 and 2. No.
CSC unknown.
No. One of the acknowledgement, my lord.
It says unknown.
Unknown and
All right. What is the issue?
I deposited the cost before the CSC authority for new meter connection, which is at page 57 in the month of September 20 in the month of December 2020 in the month of September 2024. Now page 57. Thereafter the other flat owners.
1 minute. Hold on. এটা কি সার্ভার হয়ে গেছে? বাইশ করে দেওয়া হয়েছে। Yes.
I deposited the cost for new meter connection. Subsequently, the representative of the CSC authority went to my premises. The other flat owners raised objection in installation of the new meter.
Flat owners mean you are there in a flat. In a multi-storied building.
Multi-story building.
All right.
And what has happened? I am the one of the flat owners.
All right.
Now, I raised a complaint, my lord, before the officer in charge, Pornosi police station, which is at page 58. No steps have been taken. Then, my lord, I moved an application 163, the new, my lord, PNSS 2023 for getting, my lord, police assistance before the magistrate. Page 60. Magistrate was pleased to give direction that let there be a police assistant at the time of installing the meter, and no breach of peace took place. Then, my lord, kindly see the another complaint, page 67. 4 times the CSC authority represented went to my premises, but they resisted by the private respondents.
Why will the private respondents resist in grant of electricity to you? Everybody is enjoying electricity in that.
And the secretary of the, my lord, the housing society,
Did you not pay the charges or something of that sort of the?
No. Without any reason. No reason.
Without any reason.
Without any reason.
I have to install in my premises.
Without any reason.
Yes.
I'm the developer.
We have no allegation against the developer. We have the.
You have handed over the property and you have gone. You are no longer there. Developer is no longer over there. Once the property has been handed over, developer hardly has a role.
At this juncture, your lordship knows that the CACA has made all endeavor to keep the connection. Yes, there is an existing service.
Right.
We have to install a loop meter.
Right.
But whenever we have gone, we have been seriously registered by the private respondent, and in the service place, there is a padlock. Until and unless there is a direction upon the police authority to break open the padlock, and with the police assistant, we are ready and willing to install the meter, lordship.
Is there any block meter also?
No, this is not a question of block meter.
This
This is a building,
loop
and
meter?
there is a, your lordship.
Individual meters,
Yes,
everybody's name is there. Oh,
Your
what
lordship
is the
knows.
reason for
This is
their
what can be done?
And
But
can you see the
probably there
respondent
is a rift in the relationship between the petition and the private respondent.
maybe, but for that reason, electricity will not be.
No, we are not there. We are not
I
standing.
have
Yes.
followed it, but this is the reason
Lordship.
for objecting.
PK Mishra, the secretary, refused the service.
My lord, I have something to say, my lord.
Oh, yes.
My lord, made against the police authorities are not correct.
Not correct.
The petitioner made an application under sections 163, subsection 2 of BNSS. Then, my lord, an order was passed. But in the order, my lord, kindly see page 60. There is no direction upon the police authorities to give police assistance at the time of installation. Kindly see page 60. So, my lord, the submission made by the learned advocate for the petitioner is incorrect. Secondly, my lord, it is not true
Page
that
60,
police authority
kindly see
has not
page
taken any.
Page 60, kindly see the lines.
Yes, that I referred.
Also
Secondly, my lord, it is not also true that police authority did not take any action. My lord, on the basis of the order passed by the learned executive magistrate, second court Alipur, an inquiry was held, and there was a date to file the report. But I have also, my lord, a report for me from the my lord Premature police station. There an inquiry was held, and it has been found that 6 and 7 they made resistance.
সেটাই হয়ে গেল, হয়ে গেল। আবার ঠিক কথা বলেছি, সেটা আর আমি কি করে জানবো যে
না না ওই শুনছি কোর্ট থেকে দিত 60 তে কোথায় অর্ডার আছে
ছেড়ে দাও না, তুমি বলে দিস, আমি করে দিচ্ছি।
Are you the owner?
Yes, yes, yes. I have attached the deed also.
Show me.
Which is at page 16 onwards. And the schedule is at page 32.
All that two-storied car parking space.
Yes.
You want electricity in the car parking space?
Yes.
You don't have electricity in your room?
No. I only purchased the 2 car parking space.
Yes. So the reason for objection is that you constructed the car parking space in the common area. That is the reason they are objecting to the grant of electricity.
No, I have not raised any construction.
The developer must have raised it.
But developer appearing the learned advocate for the developer.
Yes. Will the learned advocate agree that yes, I have made unauthorized construction?
No.
Then?
But I purchased 2 car parking space, my lord. I have a right to get electricity.
Yes, yes.
That's why, my lord, I deposited the cost. And the common passage is there also. With the right to use and enjoy the benefit of common passage.
Who is in possession of this car parking space? You?
Yes, but without electricity.
Why do you require the electricity? At the night time you go over there. Isn't there any electricity in the area?
My car parking space will be, my lord, without my lord, electricity.
Why? What do you want the electricity for? If it is in the daytime, it is not required. Cars will come and go. It's not that you are going to stay over there.
No.
It's not that you are going to do any business, a shop or nothing of that sort. It's a car parking.
Kindly see the application, page 57.
Right. What is there?
Kindly see in whose name?
Bhandari Motor.
I am the owner of the, my lord, Bhandari Motor, my lord.
You are not taking it in your own name. The car parking space. Abhijit Bhandari is the purchaser.
Yes.
And the application is made in the name of Bhandari Motor. Why? Why? What business? You're going to do some business over there?
No. Kindly see, my lord, page 55 once.
55. Yes.
Kindly see the enlistment by trade license.
Trade license? Are you doing business over there?
No.
Then?
Trade license, kindly see the holder name, Abhijit Bhandari. The petitioner before you, lord.
You made the application in the name of Bhandari Motors.
Yes.
Why? Why will the application be made in the name of Bhandari Motors? Page 57 you've showed me?
Yes, it's 57 that I have seen.
Bhandari Motors.
Yes.
So it is not a commercial unit.
Not the commercial unit, but my lord, I need my lord electricity in
Tell me one thing from page 57, load is 0.050 com. What does com mean?
Commercial.
From the car parking space, you want commercial connection. For what purpose?
just to my lord, kindly.
Because they have shown, because our
kindly
duty, whatever the document they will furnish, on that basis, we will make inspection and we find that there is an existing service where we can install the electric loop meter, lordship. Now the question whether he have taken the permission from.
No, do you all permit commercial electric connection in a car parking space?
So far, whether they want to, that I have to take instruction on that.
Because this is why I inquired, what does this com mean?
Lordship.
If com means commercial and from a car parking space, this court is not going to give any permission.
Electric vehicle, kindly see my lord, page 57.
On that way, I have to take instruction
Take
on that.
instruction. Please come.
Kindly look to my lord, page 57 once.
Yes.
My lord, we are holding my lord electric vehicle. Kindly see the Bhandari motor EV. That is the electric vehicles. For charging my lord, we require to my lord install my lord new meter.
Mm.
And it is commercial. Commercial.
Uh, the petitioner alleges that because of the objection raised by the private respondents, private respondent numbers 5 to 10, comma, he is not being given new electric connection despite payment of the service charge and security deposit in September 2024. Stop. On a perusal of the documents annexed to the writ petition, it appears that the application for obtaining new connection was made in the name of one Bhandari Motor EV, and the load sought for is 0.50 kW within bracket COM in the ground floor of the subject premises. Paragraph. The title deed annexed to the writ petition mentions that the petitioner purchased 2 covered car parking space in the ground floor of the subject premises. Stop paragraph. The application for new connection, however, has not been made in the name of the purchaser, that is the petitioner herein. Stop. The application has been made by one Bhandari Motor EV, of which the petitioner claims to be
Page 55.
petitioner is the proprietor. How are you related to this? Are you the proprietor of or what?
I'm just holder.
Holder?
Numbers. Mrs. Bhandari Motors, the name of the CE holder, Abhijit Bhandari.
Listen, certificate of enlistment has got nothing to do with the grant of electricity connection. Then how are you related to Bhandari Motors? কি বললাম? Bhandari Motors stuff. The petitioner has annexed the tax receipt issued by the Kolkata Municipal Corporation to show that the petitioner is the certificate holder of the certificate of enlistment in the name of Messrs. Bhandari Motors.
May I take leave?
If your lordship kindly see page 54, nature of trade, page 54. I am just drawing your lordship kind attention, though it's not. Nature of trade, two-wheeler and purchase.
Seller of
Yes.
two-wheeler and purchase. ঠিক আছে? Stuff. Messrs. Bhandari Motors have been enlisted for sale of non-food items - two-wheeler and purchase. Stop. Paragraph. Learned advocate representing the state respondents has obtained instruction from the officer, from the inspector, from the officer in charge of Konnosri Police Station, signed on 20th of November 2024, wherefrom it appears that in terms of the order passed by the learned executive magistrate, second court, Alipur, 24 Parganas South, in MP case number 3263/2024, dated 11th September 2024, under section 163 within bracket 2 BNSS 2023. An inquiry was conducted. Stop. It was revealed that there is a long pending dispute with the petitioner and the other flat owners of the multi-storied building regarding installation of CESC meter at the common parking place where the petitioner had made the room. Stop. Next. Learned advocate representing the respondent number 11. The developer submits that after sale of the subject property, the developer does not have any role to play. Stop. Paragraph. Learned advocate representing CESC Limited submits upon instruction that inspection was sought to be conducted.
Already conducted 4 times, already gone there for giving connection, but couldn't give.
Achha. That these submits upon instruction that on 4 occasions, CESC personnel visited the site for granting connection, but were severely resisted by the other flat owners. Paragraph. Learned advocate representing CESC Limited is directed to revert with instruction as to whether the connection sought for by the petitioner Now, whether commercial connection can be given in a car parking space where certificate of enlistment has been where a certificate of enlistment disclosing a certificate of enlistment has been issued disclosing the place to be used for business purpose. Page 55, please see. The business address is 154. That is the place where the connection has been sought. It's a car parking space. And corporation is permitting to run business. And you want electricity to be given to there.
For charging.
For
EV is the electric vehicle, my lord, for charging the vehicles.
But then you want to do business from there. How can you do it? How can you do it?
It's just only charging, nothing more. For that reason, I'm asking for commercial.
Leave is granted to the advocate on record of the petitioner to implead Kolkata Municipal Corporation as party respondent to the instant writ petition.
The application for commercial supply of the electricity is due to the Bhandari Motors. It is also commercially commercial name of the business, and for that reason, I am applied for commercial.
Yes, you implead KMC as party.
Now, whether I have to take instruction or the KMC will come forward and give that.
No, KMC will come forward and say how the certificate of enlistment has been issued, and you will take instruction as to whether commercial connection can be given
in the
a
car parking
space for running business.
Lordship.
You will. As party respondent in the instant writ petition and serve a copy of the writ petition upon Mr. Shapon Kumar Devnath, learned advocate, who usually represents KMC before the court. Released on 27th. Acha, আর একটা জিনিস. Affidavit of service is taken on record. Stop. Learned advocate for the petitioner is directed to take back the
private respondent
copy of the unserved writ petitions by opening the same from the envelopes. Stop. The envelopes with the endorsement of the postal authority shall be retained with the records. Jana Babu. You open these envelopes, take back the writ petitions. The file, the envelope shall remain over here. Ar ekta jinish. Leave is granted to the advocate on record of the petitioner to forward a letter to the officer in charge, Pornosri Police Station, for onward transmission to the non-appearing respondents, non-appearing private respondents, communicating the order of this court. Stop. In the event the private respondents are not represented on the adjourned date, ex parte order will be passed.
Deeply obliged.
You give a copy to the police will forward it to them. বুঝতে পেরেছেন কি বললাম? এনভেলপ গুলো থাকবে
I'm appearing as in person. I'm seeking leave before your lordship for urgent hearing of one matter. My subsistence livelihood has been affected.
Yesterday, I told.
I have done the affirmed the before the commissioner of affidavit. I have already affirmed. Filing only left. Today I will be filing. Your lordship kindly permits me leave for hearing of the matter on Friday.
This is not the time to mention.
I am
right?
ill, my lord. I am taking some medication, and I have to regularly visit.
Tomorrow morning, come at 10:30.
As directed, my lord. I'm grateful.
Yes.
My lord, I am for the petitioner.
Sir, I appear for the respond number 5.
My lord, item number 6. We are the secretaries of the respective unions of a mine.
Objection. My lord, we are the.
Let me understand who he is. You raise objection. I don't know what the matter is.
That's why I said.
Yes, yes.
Yes, my lord, and we challenged.
Who are you?
We are the secretaries of the respective unions.
Item 6.
Item 6.
I can see only one petitioner over here.
Yes, I'm the secretary. There are 3 petitioners, lordship.
The list contains only the name of Nishit Baron Chattoraj.
Petitioner.
All right, there are 3 petitioners. Then
There are 3. Now, in respect of Chinakuri coal mines, we have our unions operational. Now, Chinakuri 3 coal mines, this is one of the coal mines run under the Chinakuri group of coal mines. Chinakuri 3 is operational coal mine. Now, in the recent past, in 2022, the government has come up with a draft consultation note on revenue sharing model through private sector participation in development of non-discontinued, closed and abandoned mine. And that draft was also accepted. And they started to operate the mines and this particular program to lordship the revenue sharing model through private sector participation in development of discontinued, closed and abandoned coal mines. Now, Chinakuri 3 is operational presently. Now, what has happened?
They are trying to close it down, and this is your grievance.
Yes.
All right, 1 minute. Union of India, 1 and 2. Coal India. Who is for Coal India? Nobody is there. Eastern Coalfields.
I appear for 5 and 7, my lord.
5 and 7. Eastern Coalfields. And nobody else. Who are you?
I am the successful bidder. A tender, my lord, which was held in 2022, is now being challenged, my lord, by my learned friend, my lord, here. My lord,
Tender for what?
Tender from, my lord, the operation of, my lord, the coal mine.
For operation. Yes. It's not that the coal mine will be shut down.
No.
The coal mine will be in functional state.
Yes, my lord. And their grievance, if I'm not mistaken, is that 53 workers have been, my lord, transferred. That is for the ECL.
Lordship,
Here,
lordship,
and I am not made a
it can be only operational through the private sector once it is a discontinued mine. My case is, since it is not discontinued or abandoned or closed, since it is running and there are reports, this cannot be given to the private
sector.
sector.
It is challenging the tender, my lord. I am the successful bidder.
But Chinakuri 1 and 2, I do not have any problem. What Chinakuri 3?
My lord, I appear for the respondent number 5, my lord. The mines, my lord, are, my lord, I am a subsidiary of Coal India. Now, lordship knows Coal Nationalization Act, my lord, which says, my lord, coal can be extracted by, my lord, only the government agency. That, my lord, is impliedly revealed by the Act 4 of 2018, my lord, which, my lord, permits, my lord, this type of operation, my lord. Those are all on place, my lord. My lord, Coal India has issued, my lord, a regulation, notice, my lord. That's board meeting, my lord, as per reliance on the Act, which came on the basis of the Supreme Court judgment on the basis of EMTA coal, my lord. What has to be done? Now, my lord, though mines, my lord, which are, my lord, not either discontinued, abandoned, suspension, or, my lord, there are less, my lord, minerals involved. Materials are there, my lord, because it's natural resources, my lord. That can be extracted by appointing a private miner, which is called, my lord, mine developer operator, which is called MDO. Now, my lord, that MDO, my lord, has to be appointed by a
fair tender process. That's the guideline laid down. Tender process saying this particular mine is being given to the MDO was issued in the year July 2022. These are all part of the petition. This is the open tender out in the website. Thereafter tender process was done. Mr. Chatterjee's client was successful there. The process is continuing. Thereafter work order has been issued. Now in this context, in 2024, my learned friend comes and challenges the entire process. What this person who has been appointed as the MDO cannot operate the mine. It has to be operated by the age-old mechanism of ECL. Now, deepest of respect, Lordship will not mind me. It's they are the employees of ECL. They cannot interject a policy of a government which are on board unless they are irrational, perverse, unconstitutional. That could have been if they have terminated their employment. I have not done so. There were, I'll point out, these are to be told on affidavits. There were 502 employees forming in his association. 53, when I gave the notification, you please apply for transfer because I'll transfer them. That's permitted under the service rules.
Transferred them where? Because the
Where
coal mine is there.
My other mines.
All right,
Where
you want
I
to
am not terminated, transferred to my other mines within near vicinity. That is one of the terms and conditions of the service regulation of ECL and also the employment letter. 53 has already accepted. Or there are others have been already transferred to the other mines. So 435 has been done. Remaining 67, there was an issue. Out of that, 48 are already accepted the posting. So the issue is now with 17 members who says they should not be transferred to some other area. But the majority, I hand up the chart, I took instruction. This is the scenario today as on.
There once, if I'm not.
Kindly see, my learned friend is talking about the policy. May I place the policy once?
No, but then who are you to question the policy?
The policy says they cannot be appointed. My lord, I being a stakeholder in the mining industry.
What is your stake?
My stake is that, Lordship, this is a false statement that it is non-operational. If they say so, operational mines cannot be given to in the hand of the privates. It's the policy. Kindly come to this policy, Lordship.
And
The process on the basis of which they are relying on. This is 2022 policy, Lordship. Kindly refer to this.
What were you doing for so long?
This policy I have not challenged. I am asking your Lordship to direct them to act in accordance with their own policy.
No, but then in terms of the policy, steps for tender were taken in the year 2022.
Tender cannot be granted in favor of Chinakuri 3. It's only for the non-operational, closed and
for
abandoned.
Chinakuri 3 also tender process was initiated in 2022.
Yes, no.
What were you doing?
No, no.
This is what the
2022 tender process, Lordship, kindly see. One jugglery was played. They are now using the Chinakuri group. All mines under Chinakuri group. Kindly come to the tender.
What is this Chinakuri group?
There are Chinakuri. It's a place.
It's the name of a place.
Yes, it has three mines in question.
All right.
My learned friend says the Chinakuri 1, 2, and 3 are independent mines. So if 1 and 2 are closed, 3 is operational. The 3 should not be given. Now the tender was in respect of the Chinakuri project. Kindly have a look at for a discontinued mine. This was in vogue from 2022. Why the challenge today? It cannot be read in the writ petition.
And it is non-operational.
It's non-operational. Zero.
They have given this list contradicting with their own report, Lordship. Kindly come to the report placed by their own manager.
2022, why this should be interference.
Manager has
challenge
given
to the policy. He says MDO cannot be appointed. He only grievances is what? He's an employee. He's representing the employee. His grievances that his services cannot be terminated. That is all. In law he can do that. Today I have his members 435 have an odd and there are few more who have already, there are 17 of them who is creating the dispute. And the person who has affirmed the petition he holds the quarter against whom eviction proceedings are there. Well, this is a
Petitioner
counter blast.
number 1, 2, and 3, nowhere it is mentioned that they are representing any union or anything.
Lordship, that's why, Lordship, I have given one
Independent, they
application. I
come.
have filed one application, Lordship.
That's
That
the
was not given,
tender.
the
Well,
authorization
our
was not
trade union,
annexed
well,
on that day.
they have some members. They are protecting the well, grievances of the members.
Oh, you want them to be added as the added petitioner?
Yes, madam.
Colliery
The
Mazdoor
application has been
Sabha, Colliery Mazdoor Union, and West Bengal Colliery Mazdoor Union. How many members are there in your union?
Lordship,
Have you
that-
disclosed?
I have given
Because
the chart.
the figures that is
I am
being
given the figures.
placed before by
Lordship,
learned counsel.
Lordship, I will disclose. It's not disclosed, I will get that figure.
17 are the who as Miller says they should not be
Lordship,
transferred.
for the
I'll take
time
care
being,
of that also.
Lordship, may,
Now this person, Nishit Baron, petitioner number 1 is aged 68. He is a retired person. And you say he is a stakeholder?
yes, secretary of the union.
Secretary of the union.
And
He
he
has retired from job and he still continues to be
continued,
the
yes.
secretary of the
He can do.
union.
He can continue, Lordship.
He can continue and he will interfere with
It's
whatever.
not the interference, Lordship. I am saying them, I don't want to interfere. Let them strictly abide by their own policy. Kindly see, policy I have handed over.
Because they say they are abiding by their
Lordship,
policy.
let them abide by the policy which I have handed over. Lordship, kindly see. Lordship, kindly see once. Lordship, the policy I have handed over. Lordship, this proposal portion I have. This internal page 2. To promote and
Is this what you handed over? The meeting notice and these documents?
this is the policy.
This is the
Yes,
policy.
madam. The policy. Lordship, kindly see stakeholder consultation on revenue sharing model for discontinued, closed and abandoned mines. This proposal.
Where is the proposal? Yes, stakeholder consultation on revenue sharing.
Yes, my lord, kindly come to
16th of February 2022.
Yes, I only pray this policy should be added. Why? To kindly come to internal page 2. To promote an optimum utilization of coal resources in the national interest, the government is eager to include the private sector in operating, closed, abandoned, discontinued mines through the mechanism that would benefit both government and private sector.
Where are you reading? I cannot find out.
Lordship, internal page 2, Lordship.
Internal page 2 is a distribution list.
Lord, after that, Lordship.
Internal page 2. Yes. Yes. Proposal.
Proposal.
Yes.
To promote an optimum utilization of coal resources in the national interest, the government is eager to include the private sector in operating, closed / abandoned / discontinued mines through a mechanism that would benefit both the government and private sector. The Ministry of Coal is attempting to build a vision that includes private sector participation in order to bring these abandoned mines back into operation. The fundamental premise is that the private sector will bring in much needed efficiency through lower overhead expenses or state-of-the-art technology allowing coal to be produced at commercially viable rates, also subcontinuing mining operations to private players in these discontinued and abandoned mines is a more capital efficient way forward to the increase of coal population. Reduction. It's simple to say that administer contractual model in line of the government's efforts to promote ease of doing business requiring minimum regulatory burden of the modernizing these discontinued abandoned mines and encourage private sector participation will be developed. Lordship, as part of enhanced domestic output, reduces import CIL will start such and such. Then Lordship, kindly come to the process 10. In revenue sharing mechanism, the concerned CIL subsidiary will select a mine operator to mine the coal through the transparent bidding process, and the bidder will have marketing freedom to sell the coal at market determined price. On the lines of commercial mining auction process, the sole criteria for award of mines will be revenue share, quoted on per tons basis after fulfilling the liability of paying all the statutory dues. The revenue generated from the coal produced will be shared with the concerned subsidiary at the bid percentage share of the value of the coal on per ton basis, which the bidder has already quoted in their bid. Now, Lordship kindly come, I'm skipping this. Then Lordship kindly come to 14. The mine operator is responsible for reopening, developing, operating the mines. So first is reopening. Lordship, if this is closed, then the question of reopening comes. If it is not closed, reopening is not required, it is continuing. Now, Lordship, I will show from their documents that how they have deviated from their own policy. That's why I am before your Lordship. Lordship, kindly come to page 51 onwards of our writ petition. 51 is the document which is submitted by the director of nominated owner of Eastern Coalfield Limited to the Coal Controllers Organization, dated 30th March 2023. And this is in pursuance to Sub-Rule 2 and Rule 4 of the Colliery Control Rules 2004 in accordance with the Gazette of India, such and such. Now, this says that I, being the competent authority of the company, hereby declare the coal grades of seams, combined seams of different mines of ECL attached in annexure such and such. Then, Lordship, it gives the entire thing. And where Lordship will find Chinakuri in page 56 against number 235 and 236, Shodhpur, Chinakuri 3 pit and Chinakuri 3 pit under Shodhpur. In page 56 against 234 and 235. Lordship found Chinakuri 3. So my only contention today is that if it is operational, from record it reveals it is operational, this policy will not be covering that. They can operate in Chinakuri 1 and 2 by closing it because they are already closed. So they can't utilize this policy to close down a running mine. That is only my concern. I am before your Lordship.
They will not close down, they will hand over the
Now the question is, Lordship,
operation only.
that cannot be done by pursuant to their own policy. Their policy does not permit. This is a policy for discontinued, abandoned and closed mines. And thereafter, Lordship, hurriedly on 28/9, no, wait a
The page 56 that you placed,
My lord.
does it mention that coal is extracted from that place? Where
My lord.
from does it appear? It
My lord,
declares
that's
the
why they-
coal grades. It's only declaration of the coal
On the
grades.
stream of the coal.
My lord,
Yes.
even the daily production report.
Where is it?
I am
There's
giving.
nothing in the petition. Milord.
It just come to me today. Daily production report.
Production.
It is signed on 22nd October 2024. Chinakuri mine number 3.
24th, if your Lordship takes, if you are on the same page, Milord, if my lord and the page, we are in the same page. This is the report. It is, Milord, closed. According to us, I have it. I can put it by affidavit. Milord, after all, Milord, his grievances, Milord, can be, Milord, that he is losing an employment. Milord, he is not, I am not doing.
From here you want to say it is functional?
This is the report.
Where is
Full
it?
production report.
Where is the production amount?
The actual.
My lord,
It's nil.
It's nil. I don't.
It's
this
a
is
nil
my
report.
Actual.
It is a nil report. Total coal is nil.
Lordship, on 20, this is
24th, 2nd of October 24.
Kindly look at the last one, Milord. I'm
Lordship,
sorry, Milord,
kindly
I'm
come
little
to the
bit-
actual 20.
Where is it?
This the last column, Lordship. Cold UGI 28,744. Actual.
Actual on date opening stock. Actual is 0.
Zero.
Now kindly come to
Grade 4 something is there. 5, 6 is 0.
it's 0 in mine 1.
Where is mine one? Milord? I
Entire
cannot-
is coal mine 3.
Yes, my lord.
This is coal
Name
mine
of
three.
coal mine
Yes.
Chinakuri mine number 3.
And kindly look at what is the interim order he has spread today. He has said stop the entire process.
Lordship, kindly come to this last page.
You take proper instruction, the way you are placing it, it does not appear that the unit is functional.
Lordship, kindly come to this third page, Lordship, third one.
নীলই তো আছে
Third page, this is
This-
my
Maybe
free,
favored with
yes.
copy কপি একটা দেবে
এটা রয়েছে
তুমি তোমার পক্ষে
This is actual 29,008.
আরে
Lordship
প্রোডাকশন
has got it.
আরে প্রোডাকশন নীল হয়ে গেছে দাদা
Actual production, Lordship. Then this is a report dated 24/10.
Where? Page 3, where?
Page 3, Lordship, on the right side.
Right side, I see nil.
After nil, Lordship.
Coal total. At the bottom is nil.
নীল
Then UG, then 29,000.
that's not production that is not production Miller I have given
It's
the
actual
chart
production,
in
Lordship.
this.
Kindly see.
Because this
No,
is a
no.
process. He wanted to stall the transfer. I've acceded to.
Lordship-
I've acceded to transfer. at
Lordship,
this point.
may I say one thing, Lordship? Kindly see then what does it signify?
What?
This
It
actual-
signifies it's nil.
It's
The numerics, Lordship.
You inquired, the authority says it is nil.
This is not nil,
I
Lordship.
have
Since
to-
it
I'll
was
file an
operating.
affidavit. I'll file an
Why it
affidavit
should
to the
have been nil? It is, since it is operating, they accept.
No, they don't accept.
Don't accept.
Where do they
nil.
accept? From the very beginning, they say it is non-functional.
Lordship, this production
production
report,
is there.
then
Given Miller
Lordship,
my-
then I will
And
show your
this
Lordship.
policy, Millard, what he is showing, kindly have a look. It has a schedule.
he challenges my tender.
Millard, I really don't
Lordship,
know.
this-
And
so far
employed, it's
this-
Millard, don't mind me saying it's master-servant relationship. Now, Millard, there is a clause in that if I, Millard, have to transfer, I can transfer you at any place. I, Millard, say, Millard, they, Millard, raise this issue. It's a policy of union, Millard, which Millard, Lordship knows, Millard, challenge can be on 3 grounds. Now, Millard, I say I'll
No,
give
we
you
are not going into that. He says he doesn't challenge the policy. He says you act in accordance with the policy.
acting in accordance
So
with
for
the
the
policy.
purpose of acting,
Yes.
you are only required to
I'm
show
showing it's
that
in-
it is non-functional.
the document shows that,
This
Lord,
is suffice.
his
Nothing more
lordship
than
sees
this.
his document.
Look at the prayer, Millard one.
Kindly look at the prayer.
So forget the press.
Ah.
Proposed
Still,
to be-
Millard. That's the chart I have given.
Lordship, then what is the actual number which is given?
No, that is not the
That
production.
is nothing
Then
but
this is-
instruction.
This is production year.
Yeah.
And then target and actual. Then why actual will be written?
টার্গেটটা তো জিরো
Target.
Why actual will be written?
Please come. The petitioner alleges that
Great.
Eastern Coalfields is not acting in accordance with the revenue sharing model
Lordship, one thing, Lordship, kindly see. The
through the
next column,
private sector
operating stock on
participation
21st/10/2024, it
in-
gives
in development of discontinued / closed / abandoned mines. Stop. The petitioners stress upon the fact that Chinakuri-III coal mine is an operational one and the revenue sharing model could not have been applied in respect of the said mine. Stop.
The Supreme Court.
Learned Counsel representing Coal India Limited, Eastern Coalfields Limited, submits upon instruction that the subject coal mine is non-functional. Stop. Paragraph. Let a report be placed before this court disclosing the status of the subject coal mine. How soon can it be done?
Millard gives me 2 weeks time, Millard. I have, in fact, Millard, this will be the Lordship's query. I have given that. I'll support it by
This,
open affidavit.
right, nothing more than this.
Even
So why
affidavit to
2
such
weeks? You have the paper over here.
Yes, I have it. I'll file it.
Yes,
by an
file
affidavit.
it by
Nil
way of
is
an-
written, nil, Millard. I cannot.
Yeah, you cannot improve. Whatever is
What
there is
there?
here.
Nil, Millard.
it will be recorded.
1 week Lordship will give me.
Yes. কি বললাম? Report বললাম তো, report by way of an affidavit. By আজকে 20 তো 27th with an advance copy to the learned advocate representing the petitioners by 26th.
Grateful, my lord.
Soft copy you can pass
Can
on.
give him, my lord, here and now, my lord. In fact, I gave my lord 2 copies, my
Acha.
lord, by mistake.
List the matter on 28th.
Grateful, my lord. Grateful.
But with respect to me, I was wondering, my lord, whether your lordship would add me formally. Because
If the writ petition goes,
there is no problem at all.
then
Just for the.
as of now, the court is not inclined to hear you.
And my
Because
lord,
my presence
my lord, Director General of Mines, my lord, has to be made a party, my lord, because this has his discretion. He's not a party. I will not
Sorry,
function under the Director General.
Kindly give me liberty, lordship, I'll do it today here.
I will not function under the Coal India. Coal India, my lord, has a Director General of Mines who is sitting there, my lord. He's taking
Acha. Leave is granted to the advocate on record of the petitioner to implead the Director General of Mines.
DGMS. Lordship will say DGMS. That's the will.
What is this S?
Director General of Mines and Safety.
And safety.
And safety. Mines and safety as party respondent in the instant writ petition. Who will accept service? It has to be served. Or the Union of India Council can separately. It has to be served separately. Acha. And serve a copy of the writ petition upon the added respondent.
Lordship, my application so far, the addition of parties concerned,
Is it required? Why?
it's they will take up this point, Lordship. That's why I
Which point?
that we are not represented, means we are representing the unions,
Yes.
and unions are not made a party there. So that's why I made
Have you
this.
mentioned in the writ petition that you are representing
Yes,
the
yes, yes,
unions?
yes.
That is there.
Yes.
Acha. The application for addition of party made by 3 applicants as petitioners stands allowed as the petitioners in the instant writ petition represent the subject unions who filed the application for being added.
Grateful.
Disposed.
Only
Application stands disposed.
only records, my lord, my submission, my lord. Lordship says it's not relevant. My lord, they have accepted transfer the members and they have already joined. Only 17 are outstanding.
You
17. If that is a no cause of action.
you mentioned this in your report.
Yes.
I am not adding anything over here because if you say that the coal field or the coal mine is non-functional by way of an affidavit, the court will accept that. Thereafter, let us see.
Grateful.
কে ডিপি বাবু ইন্টারভিনারের কোনো অ্যাপিয়ারেন্স রেকর্ড হবে না। হ্যাঁ
My lord, I am for the petitioner, my lord. My lord, compromise talk is going on, my lord, between the petitioner and the respondent. My lord, kindly adjourn this matter for 15 days, my lord.
Now, my lord, this is a infight between the mother and the daughter. Lordship, remember the last occasion, and the police authorities has been in that house, my lord, and they found that is under lock and key. So in the meantime, when they says that the talk of compromise is going on, so let us and his lordship on the last occasion directed us, my lord, to attach this order before and accordingly, my lord, the authority has done that.
Not attachment. I made for onward transmission
Yes,
to the
onward
respondent.
transmission, but I was
Nobody was there, so it has been pasted on the wall.
And they have also gathered information that their frequent comes into that house, not regular basis. Both that husband and the wife, that is the daughter of this lady, my lord. They are not the regular in that place. And nobody also don't know where are they staying, my lord, in the locality, lord.
But I see private respondent was represented in the earlier occasion. Mr. Shayan Sinha, Adil Nasir and Shoham Kumar, I see their appearances recorded.
Now they are.
We serve pursuant to your lordship direction and we track report I have filed.
একটু দেখুন তো জমা দিয়েছে কিনা প্রাইভেট রেসপন্ডেন্ট দেখতে বলুন তো প্লিজ কাম
May I file these two documents?
Learned advocate for the petitioner submits that talks of settlement are going on between the petitioner and the private parties. Stop. In view of such submission, you want delisment or what? Petitioner, delisment?
না ডিলিটমেন্ট করেছি তাহলে মামলা আউট হয়ে যাবে
No. My lord, fortnight adjournment.
List on 9th of December. State না private party ওকালতনামা জমা দিয়েছে no ওকালতনামা আচ্ছা report filed by officer in charge Jorabagan police station signed on 19th of November 2024 be written with the records.
Lordship, I'm led by Mr. Shankarnath Mukherjee. I'm praying for short possible, Lordship. I am appearing for WPS.
Why?
He's engaged in court number 11.
Start. Are you aware of the facts?
I have served Lordship pursuant to Lordship direction.
Yes.
This is my affidavit of service.
Want to include the secure carrying the purchase the property. How much is due?
66,000, Lordship.
Only 6,000?
66,000.
66,000.
I have purchased this property in auction.
Auction sale?
Yes, Lordship. Page 38, kindly Lordship consider.
38, the sale certificate.
This is the sale certificate.
Is made free from all encumbrances known to
Yes,
the
Lordship.
secured creditor.
I have purchased free from all encumbrances.
And 66,000 is the energy charges of WBSCDCL?
Yes, my lord, it's total, including LPSC, it is come 67,788.
Yes. Can you recover the money from the petitioner?
Issue has already been settled by Supreme Court.
Please.
SC99 case, reported in 2023, SC online, SC page 663. Kindly come to paragraph 26. It is SCC online. Elaborate the different state was the similar issue. Paragraph 26, clause F. Implication
At what
of an
page?
auction sale.
At what page is it? Page 9?
It is in, Lord, it is not in page number when the
Page number is there at the top. See? At the top. Second line. Page number?
11. Page number 11.
11. Yes. Auction
Implication
purchaser.
of an auction sale of premises
Hmm.
as is very basis.
Hmm.
The auction purchaser were put to notice of the requirement of clearing of dues as the public auction sales of premises on as is where is basis would include the condition of acknowledging all liabilities in respect of the said premises with or without specific reference to the payment of electricity dues. There is an obligation on person requiring the premises to verify and obtain a no dues certificate from the licensee or otherwise factor the dues while putting the bid price in the auction. and the purchaser cannot deny acknowledge the requirement of the clear outstanding dues of the premises when these are provided for in the conditions of supply or supply code. And in the concluding part at page 110, conclusion, paragraph 341. The conclusion, paragraph 341, page 110.
Yes.
The conclusion are summarized below. The duty of supply of electricity under it is not given for application considering for the condition of supply enacted under the premise under section 49 of the 1948 Act, requiring the new owner of the premises to clear the electricity arrears of the previous owner as a precondition to availing the electricity supply will have to a statutory character. Is settled by the Supreme Court.
Go through this judgment
Yes, Lordship. May
and come back.
make it not today, Lordship.
Yes. I'll make it not this week, so you get more time to prepare yourself.
Grateful.
Please come. Learned advocate representing WBSE-DCL relies upon a judgment delivered by the Honorable Supreme Court of India in নামটা লিখে নেবেন তো K.C. Ninan versus Kerala State Electricity Board and others.
Lordship.
Reported in 2023 SCC Online SC 663. ঠিক আছে? To allow the learned advocate representing the petitioner to make submission. List the matter on 25th of November, Monday. থাকবে এটা থাকবে হ্যাঁ service. Did you serve the secured creditor?
Yes, Lordship.
Now they will not come.
Certainly,
They have accepted the money and they have they have got the money, and that is the reason now they will not come. Under which police station does this company fall?
This is
Competitor.
no. This office, but the office is within the original side jurisdiction. I think from the office.
Maybe which police station? Which police station?
Police station. Calcutta 72. This either the Bowbazar police stations or the here seat. Bowbazar police stations.
Sure.
One. So 72, you'll also will find as the
I can see 72.
one part is the within the here seats police station. The other part that is the Bibi Gaon street side. Just went up to the Vivadi Bagh. That's the
SME FG India Home Finance Company, it is with the Tamil Nadu.
No, that is of
That is the
here.
head office or registered office, maybe.
There in the
But the from the
in the sales certificate itself, my lord.
sale certificate it is written.
My
Bazaar.
Kindly come to the 1, 2, 3, 4, 5, 6, 7. Just it starts the this is from top 10th line. Having its
No, Kolkata 72, I can see it. Is it within Bowbazar?
Is it within the Bowbazar?
or Hay Street? Which one?
No, no, this that part is the part of that the Bow Bazaar. This is the
You tell me, then I will pass order upon the officer in charge to intimate the. This-
that's what my client has said that this is in Bow Bazaar.
Very well. Please come. None represents the added respondent despite service. Respondent survey. Affidavit of service filed in court is taken on record. Stop. The learned advocate on record of the petitioner is directed to serve a notice upon the officer in charge, Bowbajar Police Station, for onward transmission to the respondent numbers 4 and 5, intimating that the matter will appear in the list on 25th November. Stop. In the event the said parties remain unrepresented, ex parte order will be passed. In the sale certificate, it is mentioned that the property is free for all encumbrance, and then there is this due of 66,000.
And in the deed of conveyance, it has been mentioned that all liability in future liability borne by the secured creditor.
No, but then it is
therefore what the
Secured creditor.
Yes.
And that means the secured creditor is the NBFC.
Therefore, if any subsequent dues.
Subsequent, the petitioner will bear.
Dues during that period before sale.
Before sale. It is of the secured creditor?
Yes. And if they suppress it, he has right to file a suit against them, because
that is something else, suit and everything, but in the meantime he wants electricity connection.
And that in that event that Supreme Court has decided clearly.
Yes.
And it is that the Maharashtra, Kerala and other state also their party. All are the similar issue was involved, and that's why a common judgment was passed.
Very well. Go through this judgment. Come
I have that part there is the decision rendered in respect of the dues apart from the principal due. That so far my knowledge goes.
No, electricity dues.
No, 2023 dues, but that exempted the interest part. Only the principal which is due. That I think that I have gone through 2023 judgment.
Yes, you go through it one second and come back.
But one aspect has not been considered. I will try to distinguish that aspect on that.
Yes, next day.
I'm appearing for the WTC. My lord, I'm for the petitioner. Mr. Soibal Acharya, appearing for the petitioner, is engaged in court number 23. I'm praying for short passover, my lord.
You will start. Other day you started. So you please start. What is there?
My lord, this is second round of litigation. Petitioner is the poor farmers, and earlier writ petition, my lord, his lordship was pleased to direct the RGRO.
Well, he has coming. Man.
Let him come. Let her start. Where is the difficulty?
My lord, matter relating to my lord, unmeter agriculture connection. I have deposited the security deposit.
Yes.
There was a fixed rate for tariff rate for 365 days. My lord, fixed rate is 10,800. But the authority concerned, my lord, bill raised for 105 days, my lord, to 20,500. My lord, after came into knowledge, my lord, this tariff rate, my lord, I have made a complaint before the a claim before the
station manager. Station manager did not take any step. Thereafter, I have approached before the grievance redressal officer. Given redressal officer
Passed order?
passed a order.
Yes.
The regulation 6.1 within 90 days, I have not as I have not made claim, my lord, rejected my claim. Then I have filed an appeal before the ombudsman. Ombudsman, same ground.
Yes. Now, what is the error? You took connection in 2007, 8, 9, 10.
Yes.
Your objection comes up in 13.
Yes, ma'am.
Right? Why will you have made the payment also? Now,
Against the ombudsman order, my lord, I have approached before this honorable court earlier. This is the second writ petition.
very well. Where is the error? Where is the error in the order?
My lord, earlier order, my lord, at page.
Where is the order, error in the order of the ombudsman?
My lord, this 6.1 has been turned down by this honorable court in earlier writ petition. My.
Yes.
At page, my lord, 67 onwards, my lord. My lord, at 68, my lord.
Yes.
Paragraph 5, my lord. Although the case of the present petitioner may be different from the fact of the cited, the question remains as to whether the 90 days stipulated in the clause 6.1 is exclusively can be relaxed. Then, my lord, paragraph 7.
I'm making it not today. Next one, please.
Lordship, 10 I am for the petition, Lordship, applying for new electricity meter.
I appear on behalf of WBSCDCL, my lord, pursuant to your lordship's order on 14th of November, this grievance probably has been muted.
Redressed?
Yes. This is a separate.
Are you aware?
No,
He
Lordship,
was
that-
not aware because this
I'm
writ
not.
petition has been filed by the. আপনারা তো ছিলেন তো আগে তো। No, the private respondent has not appeared. He was the private respondent in this writ.
Yes, this is Rajesh Mondal was there. Was the objector. Right. Please come.
Rajesh Mondal is the petitioner here. He was the private
Right.
respondent.
The petitioner seeks new electric connection. The one Abdul Awal Mondal and another raised objection to the grant of electricity in favor of the petitioner. Stop. A writ petition was filed by the said Abdul Awal Mondal and another, being WPA 22690 of 2024, which was heard and disposed of by this bench on 14th November 2024. Stop. The court directed the station manager to ensure that the pole is not erected over any private land and to ensure that the safety measures are implemented at the time of effecting the supply.
On that, the BLRO's report was filed where it has been stated that Rasta, my lord.
Paragraph. The station manager, Nazirpur Customer Care Center shall take steps to provide electric connection to the petitioner. By maintaining all safety norms and by not installing electric pole over the private land of any private party. The writ petition stands disposed of.
Let the copy of the order be with your lordship.
It is on records. It is there in the server. I am keeping it, but not recording it because it is in the public domain. I have mentioned the case number. I have mentioned the date. So everything is very transparent.
I'm grateful, ma'am. I am appearing for the state respondent in this matter, madam. I am from the CSC, madam.
Did you file your wakalatnama?
Madam, your lordship directed 7th of.
It is with you. That is not meant to be with you. It is to be filed in the department.
In the morning, we have only received.
Then what were you doing from morning till 3 o'clock? How long does it take to file it in the department?
Your lordship. Kindly pass over the matter for a few minutes. Mr. Bhattacharya Shonak Bhattacharya is appearing in this matter, your lordship.
As per your leadership direction, my lord, there was a direction to serve upon the
Police authority.
private respondent, my lord.
Through police.
Through police, my lord. This is the report to that effect. my lord.
Right, private respondent is appearing.
The private respondent number 5, he said that he will not appear. He will not participate, my lord.
All right, he is private respondent number 6. Madhavi Oja, son of Shudhir. Very well. What is the grievance?
Nothing. The grievance is in respect of the police, my lord. The last
Objecting grant of new electric connection.
that has been
police cost.
then my lord, the yes.
Police
The
cost.
first order was there. My lord, your lordship will find
Justice
page-
Sabyasachi passed an order, my lord.
As per direction, CSC authority went there and inspected.
inspections carried out. My lord,
Formalities has been
at
done.
that point of time, there was no my lord, resistance. Now, my lord, when they went to my lord, fix the meter, the resistance came. And my lord, the order was that to take the police help if required.
33,556.
My lord, that my lord, this is and my lord, they have given my lord 12% or more than 12. I think my lord, the number of my lord, the police officials, my lord,
36.
number 11. My lord, number of my lord, the 11 police personnel is required. My lord, now my lord, the one respondent is appearing, but the other was not intent to appear before the court. And for that, my lord,
14.
14. Then your lordship and 14. Then my lord, your lordship is direct my lord, the CRPF to also my lord, to protect
My lord,
the police
after-
authority of it. Even they are not my lord.
After doing assessment of the law and order, my lord, they have done this, my lord. They have
What is the
forwarded.
law and order issue over there?
My lord, they went there, they assessed the situation, my lord.
What
Then
is the situation?
my lord, the situation was the
14 police personnel will be required.
it has been forwarded to the commissioner, my lord. Then my lord, it has been, my lord, because if something happened, my lord, we will be answerable, my lord.
Then why only 14? Let 40 people be there?
No, my lord, that is not
No,
required,
then
my lord.
why this thing? What? Yes? You do not have any objection. Well, come up with a written undertaking from your client. I'll keep it on record. Don't take it on yourself. Next day, your client will come and say, I did not give this type of submission to my client.
Not even resisting the petitioner.
Are you aware whether anybody else is resisting?
Your lordship, there are other private respondent. Whether or not-
Only one. 5.
He is representing only respondent
I
number
am
6.
requesting on, private number 6.
Right. Are you aware whether anybody else is objecting?
Have no
You do not have any instruction.
Our client
You do not have any objection.
have no objection, your lordship. Respondent number 6 is not having any
All three. The
objection in
police
the
has
electric
served
proceeding
in 3.
to the
Three.
Oh, respondent number 4 is also there. What about the service of the respondent number 4? Mr. Famania,
My lord,
respondent number 4,
it has been served to them, my lord.
nobody appearing?
No, my lord. And this is my specific 4 and 6 action with regard to that. Shudu 5 refused to appear before the court.
Have been served, respondent number 4.
Kindly see the next page, my
Respondent
lord.
5. If I did not receive, history is not willing to participate. Very well.
4.
When can you bring the undertaking, the written communication from your client? A days.
A week's accommodation, Your Lordship.
Week's accommodation, why?
No, I don't want
He is without electricity and you want a week's accommodation?
asking Passover now.
No, I want a written,
Instruction.
please come.
Number 6.
So if it is the contention that you are going to take, what is the
Only
requirement
thing
of?
is, Your Lordship, that the respondent number 4 to 6 has constructed the meter room, Your Lordship. The meter room has been constructed with respondent number 4 to 6. There was an objection prior before that. If the electricity connection is given in that meter room, there was an objection in that part.
I didn't get you.
A meter room has been constructed in that premise.
Yes.
The construction has been construction of the meter room has been constructed with the respondent number 4 to 6.
Right.
So we were having prior objection if the meter can be given to somewhere else.
Meter cannot be given somewhere else.
Not within the
Meter room constructed by them.
Where is the place where the meter room is? Connection will be given there. Meter cannot be given anywhere in the entire premises. It
That's
cannot
why
be done.
these objections are coming, my lord.
Right. That is not the law. None represents the respondent number 4 despite service through the officer in charge, Koshpa Police Station.
My lord.
Stop. Respondent number 5 has
That's the very next page.
refused
bottom
to
side.
accept the copy of the writ petition and has mentioned in writing that she does not intend to contest the subject case. The respondent number 6 is represented by the learned advocate. Stop. Because of the resistance by the respondent numbers 4, 5, and 6, electricity connection cannot be given to the petitioner. Stop. Learned advocate representing the respondent number 6 submits upon instruction that Madhavi's son.
Madhavi Oja, respondent number 6, son of
Son.
daughter of
Madhavi.
Obeda.
How can Madhavi be son? Either it is Madhav or it must be daughter.
Daughter of.
Daughter.
Should be daughter.
Daughter of.
Acha. That the respondent number, that the private respondent number 6, does not have any objection if the connection is given to the petitioner. Stop.
Recorded that the meter room has been constructed by the respondent numbers 4 to 6.
Acha. It has been submitted that the meter room in the subject premises was constructed by the respondent numbers 4, 5, and 6. Stop. Next. The endorsement in the communication forwarded by the
Well, may I take leave, my lord?
officer in charge, Koshpa Police Station. It appears that the respondent number 5 respondent number 5 is not inclined to contest the matter. Stop. The same implies that the said respondent is not raising any objection to the connection being granted to the petitioner. Now, that the said respondent does not have any objection if the connection is given in favor of the petitioner. ঠিক আছে? Next. The respondent number 4, despite receipt of the notice, has failed to appear. Stop. The said respondent loses the opportunity to object to the grant of electric connection to the petitioner. Paragraph. Learned advocate for the respondent number 6 is directed to file a written communication from the respondent number 6 disclosing her intention not to raise any objection at the time of grant of electric connection to the petitioner's premises. Stop. Copy of such affidavit by the respondent number 6 shall be handed over to the learned advocate representing the petitioner by 26th, list the matter on 27th. Communication by the Koshpa police officer in charge, Koshpa police station, signed on 17th of November 2024 with the copy of the letter of the advocate on record of the petitioner dated 11th November 2024 showing receipt of the service of notice upon the private respondents be written with the records.
Highly object. Okay. 27th. 27th. I'm good. That I appear on behalf of the CS in this matter. My lord, remember, wherein, my lord, I have submitted that we have waived the amount. Yes. My lord, this is the letter of 13th of November, wherein we have written to the petitioner that we have waived the amount, and we have also sent a revised bill that is amounting to rupees 25,690. Today is the last date, my lord. I don't know whether they have paid or not, but we have sent the revised bill on 13 itself along with this letter, my lord.
All right. Please come. Are you aware that a fresh bill has been raised?
Yes.
Yes. Pay it.
Will pay it by tomorrow.
But
I do not know if tomorrow is the last date or today is the last date. It is up to you.
That they will pay it by tomorrow. Kindly
No. Certainly not. Learned advocate representing CESC Limited has filed before this court a communication dated 13th November 2024 made by the assistant manager within bracket commercial Howrah Regional Office addressed to the petitioner that the bill for June 2024 has been reviewed and the amount of rupees 797,322.25 along with tariff and government duty adjustments has been abated from the aforesaid bill. Stop. The revised bill of September 2024, which includes the arrear since June 2024, has been forwarded to the petitioner with request to arrange for its settlement within the extended due date. Paragraph. Next. In view of the aforesaid communication, the grievance of the petitioner appears to have been redressed. Stop. The writ petition accordingly stands disposed of.
I'm grateful.
Plea of pleasure.
This is assigned matter, Lordship. This is the case, my lord. I have obtained sanction building plan from the Kolkata Municipal Corporation in the year 2018. And 19, my lord, the Kolkata Municipal Corporation issued a notice under section 401. Lordship will find the notice in page 34.
Yes.
But at the bottom, Lordship will find the date 6/11/2019. Then, Lordship, after 3 years, they have provided one hearing. That is next page, page 35. Lordship, kindly see the date, my lord, 8/2/2022. Lordship knows, my lord,
Which
sanction
page?
building plan,
Which page?
page 35, annexure
35.
P2.
Yes.
Lordship knows, my lord, 5 years is the normal time of a particular plan, my lord. 8/2/2022 is, my lord, the date of hearing. Then, my lord, they have made communication, page 36.
How much demolition have you made?
My lord, they have taken money from us. They have taken money for regularization in two parts. Once Lordship was kind enough to say this is not permissible, but the practice is going on the Kolkata Municipal Corporation. They have in two installment. First, security deposit, 50%, and then after hearing remaining amount, totaling, my lord, 1,88,000. I have so far paid them. But now when I am going to do the work, they are standing on the way.
Please show me.
Lordship, kindly come page 36. Lordship will
Yes.
find. This is at the top, Lordship will find the security deposit.
Yes.
Building department,
400.
401,
Hmm.
415 of the Kolkata Municipal Corporation and building rules, so and so. Here, Lordship will find at the
94,000.
bottom, it has been unauthorized
94,000.
construction, security deposit, and development fees, security deposit. Total amount is amounting 94,021 only. First installment paid. Then again, my lord, their letter may kindly be looked into page 37. 4/5/2023. I'm just reading, my lord. Addressed to me with reference to above, this is to inform you that Special Officer Building is order dated so and so has been pleased to be retained the unauthorized construction on payment of fees and charges, except 4 number of RCC column on the roof and 3-storied building on the western side. My lord, I have demolished this, my lord, 4 RCC column. My lord, my submission may kindly be recorded. I have already
Please
demolished.
show me the order of the special officer.
I'm coming, my lord. Before that, my lord, this communication, what I'm coming, my lord, that is in page number 41. I'm just coming, my lord, one after another. Subject to lordship, my lord. Permission.
Yes, yes. 4 columns have been demolished. I have got the report.
Yes.
Then?
Then, my lord, kindly see second paragraph. The said order of the special officer building has been approved after 1 year, 5/4/2023 by MIC of KMC. So, my lord, that is also not permissible in any manner whatsoever. No provision is there. No statutory provision is there. In spite of that, they have relegated before the. Then you have already deposited 50% of fees. White receipt number so and so. Demand for rest 50% is being issued herewith. You are therefore asked to demolish 4 number of column on roof within 15 days from the receipt of this letter. Then, my lord, I have demolished. I have enclosed here with the photographs. Then page 39. Lordship will find.
What is the portion that you have been permitted to retain?
My lord, the portion Lordship will find. Then, my lord, kindly come to page 41.
Yes.
Page 41, my lord, the special officer building.
Yes.
My lord, there are minor infringement. First page, bottom. Means of access appropriate.
Prayer room at the roof. Prayer room at the roof. Page 42.
Page 42. I'm coming, my lord.
This is the order.
Then, my lord, before that, page 42. First paragraph may kindly be looked into.
Yes.
Here stated that the building plan was sanctioned for erection of 3-storied building by the plan number so and so with advantage of rule 142. Now the building is constructed with some deviation of sanction plan. Some projection has been made in the first floor level. Land area in so and so 133.83 square meter. Area of unauthorized construction is 23.098 square meter. It means into 10, about 230 square feet. PR pay to retain. Then, my lord, the deviated construction, considering small plot of land, but some RCC column are erected on roof. There is complaint, but address not disclosed. Unknown person, my lord. Then, my lord, the special officer building observe, PR have right of erection. This is, my lord, taken into consideration and permitted me to do the construction. But, my lord, the Kolkata Municipal Corporation Authority stands on the way. Then, my lord, there will be no obstruction of water supply and drainage facility for any additional construction. Structural stability certificate from Tanushree Dotto so-and-so, PR praise to allow a prayer room at roof. Then, my lord, kindly see, considering the appeal of peer, I am inclined to pass order as follows. The column 4 number of roof projection at second floor must be demolished as marked in the demolition sketch within 15 days, and the date of communication of failing which action of demolition will be taken by the department, cost will be recovered from the peer. Then, my lord, this projection issue has been, my lord, indicated. After compliance of part A, remaining construction work may be allowed to retain on payment of so-and-so, so-and-so. Now, my lord, kindly see their letter, 2 letters. Each letter, they are very categorically stated. Page 37, I am drawing your lordship attention
Listen,
once again.
I already have a report in front of me which mentions that you have demolished the 4 columns, but the projection at the second floor and the roof level is yet to be demolished.
True.
Why don't you demolish? Until you comply part A, you cannot go on to part B.
My lord, this projection room, my lord, lordship knows, my lord, the minor, my lord, the construction related
Minor,
rules.
major, go before the tribunal if you are aggrieved.
No, my lord, kindly consider, my lord, entire letter they have communicated, they have very categorically stated you are therefore asked to demolish 4 number of columns on the roof. They never said our communication was wrong.
Doesn't matter. The order
yes, my lord.
of the special officer is clear.
Yes, my lord.
What does it say?
Order subsequently very recently communicated. Before that, our prayer before the authority is pending. Our humble submission before this.
Which prayer is pending?
My lord, the prayer for, my lord, this particular portion, which is in projection, which
after
they are indicated.
The order is passed by the special officer building, is there any power?
Yes, my lord.
For reconsideration?
Power is there. Lordship, power is there. I wrote a letter addressed to the municipal commissioner. Lordship, kindly see second page. At the bottom, payment of fees for regularization. Before calculation of fees, order issued by the officer delegated so-and-so. I'm not reading. Review of the order. If the municipal commissioner show things.
Which portion are you
my
reading?
Lord, second page, bottom.
Second page, bottom, review of the
Review
order.
Of the order. If the municipal commissioner show thinks that the process of hearing was not followed properly, he may pass further orders after review, recall the earlier order. Our humble submission, my application is pending before the authority. And my lord, last 7 years, my lord, 2019.
This is regarding the payment of fees for regularization. This
my lord,
is not the issue.
Review of the order also, my lord.
Review of the order of what?
Review of the order, my lord, the order passed by the special officer building.
No, sir.
They have their power, my lord.
You are there is some problem. The payment of fees, explanation portion is there, and next comes the payment of fees. Before calculation of fees, order issued by the officer such and such shall be placed before the mayor. Thereafter, the municipal commissioner may by order charge fees. So this order can be reviewed. It is not the order of the special officer.
If that be so, my lord, the interpretation, my lord, kindly see, my lord. So far, they have charged this particular 1,88,000. Nothing has been supplied to us.
What will they supply?
My lord, they are charged their head, my lord, upon which head they are charging all these things. Nothing has been
You
supplied.
are not worried about the charges.
At the same time,
here the issue is the order of the special officer building, which you are required to comply. If you are aggrieved, there is a provision for appeal.
True,
you can accept any of.
True, my lord. And at the same time, my lord, lordship knows the plight of the, my lord, the municipal building tribunal that is not functioning for a considerable period of time. And now, my lord, I have got the information while coming before this honorable court. It is functioning. Our humble submission, my lord, small projection, my lord.
Go before the tribunal, obtain an order. You retain the unauthorized portions also. And the court does not.
The plan will be lapsed, my lord. Meanwhile,
go seek an extension. What can be done? This order was passed in March 2023.
No communication, my lord. No communication.
We are in November 2024.
Let them show, my lord, scrap of paper, my lord. They have communicated.
Very well. If it is not communicated, you get the time.
Yes, my lord.
Go before the tribunal.
So, my lord, at that point, lords.
The petitioner seeks for consideration of the representation dated 9th August 2024. And further prays for a direction upon the authority not to obstruct the petitioner from concluding the pending construction work at the subject premises. paragraph. From the documents annexed to the writ petition, it appears that a demolition proceeding under section 400/401, 400 within bracket 1, and 416 in respect of premises number 66 Capse, Rashbihari Avenue, ward number 88, Boro VII, India, was initiated and disposed of by the order of the special officer within a bracket building on 2nd March 2023, whereby the special officer passed order to demolish 4 columns at the roof and the projection in the 2nd floor, marked in the demolition sketch. On compliance of the aforesaid demolition, remaining construction work may be allowed to be retained on payment of fees under section 400 within bracket 1, including the portion allowed to be retained on the roof for utilization. Stop paragraph. Learned advocate for the petitioner submits that the sum demanded by the corporation has already been paid, but despite receiving the total amount of rupees 1,88,042, the corporation is not permitting the petitioner to conclude the balance construction work. Paragraph. Learned advocate representing the corporation relies upon the instruction forwarded by the engineers of the corporation, signed on 14th of November 2024, which mentions that a building plan was sanctioned in favor of the petitioner for raising construction of a 3-storied residential building, giving the advantage under Rule 142 of KMC Building Rules, 2009. Stop. During erection, the person responsible extended the building by erecting projected veranda from the 1st floor of the roof level, along with some columns over the roof of the 3-storied structure, deviating from the building sanctioned plan. Stop. Stop work notice was issued in 2019, and a proceeding under section 400 within bracket 1 of the KMC Act 1980 was processed and finally disposed of on 2nd March 2023. Stop. Recent departmental inspection revealed that the person responsible demolished 4 columns in the roof, but the projection at the 2nd floor level and the roof level are yet to be demolished. Stop paragraph. Learned advocate for the petitioner submits that prayer for review of the order passed by the special officer is pending consideration. Stop. According to the provision of the KMC Act 1980, the order passed by the special officer within bracket building is an appealable one. Stop. In the event the petitioner is aggrieved, if the petitioner is aggrieved by the same, the petitioner ought to approach the appellate forum for relief. Stop. At this stage, the commissioner does not have any power to review the said order. Stop. Next. In view of the above, it will be open for the petitioner to approach the appellate forum for remedy. The writ petition stands disposed.
Only limitation question may kindly be, indication may kindly be given.
Can this court do it? Does this court have the authority to do it?
My lord, since my lord, he is
No.
the wrong forum. Deeply obliged. This is a affidavit of service.
May it please your lordship. Lord, this is the affidavit of service. Lord, the petitioner's husband, my lord, is a life convict. My lord, he has suffered 21 years, about 10 months in custody. My lord. His case was referred to the SSRB 69th meeting in 2022. Thereafter, my lord, the instructions are that the SSRB had recommended the release of the husband of the petitioner. Pursuant to that, my lord, the judicial department has not acted upon it, and 2 years has passed, but the release order has not been passed, so far as the petitioner is concerned. And another co-accused, similarly placed, he was released way back in 2020 by the West Bengal government. So this is the grievance of the petitioner.
Show me the order of the SSRB.
My lord, we are not privy to that. My learned friends.
How from did you get to know it?
My lord, they are informed orally in the jail. My lord. And secondly, my lord, we had also filed there was a direction upon us informally to deposit the fine amount. Pursuant to that, so far as the sentence and the fine, we have also deposited the fine amount as well.
You are
My lord,
Ashgari
Begum. She is the wife of the convict.
Convict Muhammad Amzad.
Page 4.
Achha.
আমার মামলা এটা কি আছে রেকমেন্ড করেছো কিন্তু দিচ্ছে না
You are for the state. Why are you not issuing this remission come release order? The judicial department has to issue it.
Yes, my lord. I have talked with the department, my lord. They will release it, my lord. They are wanting our order from my lord.
Why?
No, my lord.
No, you cannot say
They
you
have
don't
started
know.
the process, my lord, but it is
Because I see this was sometimes on 2nd of September 2022. 2 years have passed. And you want a court's order and when the decision is yours.
the decision of the my lord. My lord.
State Sentence Review Board.
Review board has recommended for the release, my lord.
Then
The judicial department has
either you accept it or you reject it.
Well, there is a representation, my lord, at page 147, my lord.
Why will a representation be required to be filed?
That has also not been acted upon. My lord. That was also on May 9th of May 2024 by the petitioner.
What is the age of this person now?
Perhaps above 50, my lord. এখানে থাকবে 69 meeting.
Date of the judgment?
My lord,
Ashgari is 33.
Ashgari is the wife of.
Yes, Ashgari is 33.
That is also not reflected in the detention order.
No, no, 57.
Okay.
59, 59, my lord. Most probably.
Reported copy as
Not a copy.
But from the report, it transpires he is about
My lord,
59 as of now.
No, page 40 is written 57, my lord. In the year 2022, my lord, 59.
Why now 59? Acha, the wife of a life convict has approached this court praying for issuance of the remission cum release order in respect of her husband. Stop. From the instruction forwarded by the officer in charge, Law Cell, Directorate of Correctional Services, West Bengal, it appears that the State Sentence Review Board, initials caps, considered the proposal for premature release of the life convict Muhammad Amjad. Currently aged about 59 years. Was taken up for discussion in the SSRB apostrophe S RB's 69th meeting held on 2nd September 2022 and upon a consideration of the reports / inputs from several government authorities like police, superintendent of correctional home, chief probation cum aftercare officer, recommended for premature release of the life convict. The remission cum release order is to be issued by the Judicial Department on getting approval from the government. Stop. Paragraph. A prayer by the petitioner is pending consideration before the Judicial Department.
Yes, madam. We had written to the Judicial Department.
147, madam.
147. We had in fact written to all the authorities concerned.
Judicial Department. Stop. The Judicial Secretary is directed to take steps to consider and dispose of the prayer of the petitioner in line with the recommendation made by the SSRB at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. 8 petition stands disposed of.
Grateful.
I am grateful.
Service is taken on record. This also kept on record.
My lord, I am for the petitioner in this matter, my lord. I am led by Mr. Kosto Bakshi in this matter. Yes.
Yes.
My lord, in this matter, my lord, the private respondent is the elder sister of the petitioner's petitioner number 1 herein. Now, my lord, what had happened is that out of love and care, the private respondent had gifted a property to the petitioners, which was without any rhyme and reason was cancelled by the district magistrate on 6/4/2023. And my lord, from the
7 and 1 are brothers and sisters.
yes, my lord,
Right. Gift by 7
gift by
in
7
favor of 1 has been cancelled.
1, 2, and 3.
1, 2, and 3.
Now, interestingly, my lord, when the private respondent had preferred an application before the magistrate, it was in respect of 1 land, 1 gift. While the order was being passed, all the deeds, both the deeds were cancelled. Even though such prayer was not sought for by her in her application. That is the difficulty, and for that reason we have approached here.
Show me the law once.
Yes, madam. Section 23.
অ্যামেন্ডমেন্ট তো কিছু হয়নি
Section 23. The deeds were not a conditional one.
What is the age of the private respondent?
40 and 40 private respondent
69. Hmm.
That is not
The provision for appeal.
the provision
23, my lord.
Provision of appeal.
Oh, appeal. Section
My lord,
50.
kindly see section 16.
We had preferred an appeal, but it was dismissed.
You cannot prefer the appeal possibly.
My lord,
Only a senior citizen or a
My-
parent can
my lord.
prefer the appeal.
কিচ্ছু হয়নি, আমরা শুরু হয় প্রথম থেকে বল টেক ইউর ব্রেথ কিচ্ছু হয়
The
শুধু আমি বলতে
children
দিই
who is required to pay any amount in terms of the maintenance or continue to be paid. So,
My lord, it's a settled law that under the Maintenance of Senior Citizen Act, the judgments of the Supreme Court, I'm relying on the same, that if the deed was not conditional, it was not appropriate for the tribunal to cancel the deed. Here is the judgment, 2022 SCC online.
are you out of breath? Sit down. Let him
No,
continue.
No issues.
Doesn't matter. You sit down.
No issues, my lord.
Dekhi. Which portion?
My lord, kindly comes paragraph 11 onwards.
বলবো একটু বললি
Paragraph 11 on
না পেজ ইনিশিয়ালি ওই এসসিসি অনলাইন অবধি লিখেছে
SCC
সুপ্রিম কোর্ট 1684
SC 16. More particularly, paragraph number 14, 15,
Where is the deed of gift?
The deed of gift is annexed to the petition. Page number one.
Was the brother supposed to provide maintenance to the sister, private respondent?
No, it's not the brother, it's Pishi Shashuri. Wait.
Brother? Yes. Brother is was the brother
না না brother নয় পিসি শাশুড়ি বলছি তো
42 আর 68
petitioner number 1 is the son of Subarnath
Yes.
and petitioner number 7 is the daughter of Subarnath, so they are brothers and sisters. Brothers and sisters.
তাহলে it's fine. There was no as such there is no condition in that gift. It's purely my lord based on a point of law.
Yes.
It's purely based the action it's purely based on point of law. My lord kindly sees whether the deeds are conditional or not. If it's not conditional, the tribunal had no jurisdiction to cancel the deeds.
Grohita is only Rimpanath Vishwas.
The deed starts from page number 23 onwards.
The deed
There were
was
two
in
deeds.
two deeds. All right. Page 24, I can see Rimpanath Vishwas.
Yes. Rimpanath is also the party. Yes, daughter of petitioner number 1. From page number 23 to 23 to 51 is the entire, it's in entirety the deeds. None of the deeds were conditional. And the senior citizen approach for cancellation of one deeds, tribunal went one step ahead, cancelled two deeds. Wholly arbitrary and without jurisdiction.
Private respondent, what is your submission?
Though it is not specifically written in the deed that it is conditional, but it is implied that the petitioner will provide.
Imply means?
How?
Implied that petitioner will provide all this, the private respondent or the petitioner will provide all these benefits to the donee. Gift is out of love and affection.
The private respondent is a senior citizen and is a unmarried, having no issue.
Yes.
So in this particular case, the petitioner is the legal heir of the private respondent.
So
this act is applicable.
Nobody is saying that the act is not applicable.
Power is the power vested upon the tribunal. If it is found by the tribunal that the conditional that the deed was conditional and condition that they will provide maintenance.
Please show, where is that mentioned in the deed that in lieu of the deed of gift being executed, the donor will take care of all needs of the donee? Where is that mentioned in the deed?
In the deed, that is not specifically mentioned. That is not specifically mentioned. What is the reason for giving the deed?
How do I know what is the reason? It is out of love and affection. What else can it be?
It is expected that the private respondent is a unmarried and a
expectation you can expect for whatever thing. What is happening? Does the private respondent can the private respondent take care of her own needs? Can the private respondent take care of her own needs?
No, my lord, is now 68 years.
68 years. There is no source of income.
Already I have gifted all my ancestral property. That's already on
my lord.
There is no reason except this that his brother will look after.
And now what the brother is doing?
Father is having landed property and is doing this.
No, the brother is not taking care of
not taking not only that, my lord, after the execution and registration of the deed, the petitioner started neglecting me. Not only neglecting, but started started mental torture. My electricity was disconnected. My water connection was disconnected. My toilet was closed for my use. And it is in the report that the inquiry officer went to the spot for inquiry, and they, on their intervention, I was allowed to use my toilet. Still now, the main gate of the building, main gate of the house, we are residing in the same house. The main gate of the house is closed. I am using another house. He'll end up in my adjacent another owner for entering into my room. I am
Very
kept confined in one room. But in these circumstances,
Yes.
it is
My lord, I cannot say what is not on record, but as per what instructions that I have got, these are nothing, no complaints with regard to those were made.
No complaints.
My lord,
No complaints.
my
You are the donee.
yes.
This lady has gifted certain property to you, and now you are throwing her out. You are neglecting. You are not.
Absolutely no. I undertake that to look after her. I undertake before this.
The writ petition will remain pending. You carry on whatever you undertake.
Yes, I will definitely. My lord, would
Yes.
kindly consider. My lord, it
The
says
court will consider.
yes,
But not now. Later on.
my
The
lord, I
court
can
will-
also my
the
lord,
court will
undertake for a
follow
monthly
your
maintenance.
behavior.
I can also undertake for a monthly maintenance if your lordship so desires. But the order of the tribunal is absolutely without jurisdiction.
Very
Now, my
well.
lord,
The
will
court
your
will
lordship
see.
kindly allow me or permit me? So
Yes, I will.
I'm, my lord,
I will.
the maintainability of the writ petition. My lord, on
Yeah,
two, three accounts.
I have judgments. I have judgments on that.
My lord, it's a power exercised by the district magistrate under the statute, quasi civil jurisdiction. The writ petitioner in the writ petition, to my understanding, has not agitated violation of any statutory provision or violation of any fundamental right. Any order passed by the district magistrate exercising power under Rule 9 of this particular statute, my lord, to my understanding, is revisable. Number one. And my lord, the writ petitioner, his
I'll
age is,
hear you later on.
my lord, the writ petitioner is
Let the respondent number 7 file an affidavit. Please come.
my lord.
You disclose whatever you've got to say by way of an affidavit. The petitioner is aggrieved by the orders dated 6th and 8th, 6th April 23 and 8th June 2023, passed by the subdivisional officer, Tehotto, under the Maintenance and Welfare of Parents and Senior Citizens Act, 2007. Stop paragraph. It has been submitted that the authority acted without jurisdiction in passing the impugned orders. Paragraph. The petitioners are the donees in respect of certain properties by the respondent number 7. Stop. After 7, who is a senior citizen, currently aged approximately 70 years. Stop. After execution of the deeds of gift, comma, the petitioners প্যারাগ্রাফটা কি দিয়ে শুরু করলাম না ঠিক তার আগে
The petitioners are the donees in respect of certain properties by the respondent number 7, who is a senior citizen, approximately 70 years.
ঠিক আছে have started neglecting the private respondent. Stop. According to the private respondent, comma, the petitioners are physically and mentally torturing her, comma, not allowing her to use the toilet, comma, not allowing her to use the gate, the main gate. And what else?
Electricity was disconnected.
Oh, comma the disconnected the electric supply and
Taken 1,12,000 from my account.
and have withdrawn rupees 1,12,000 from her bank account. Stop paragraph. Let an affidavit be filed by the respondent number 7. Disclosing her stand. Paragraph. The copy of the affidavit shall be served upon the learned advocate representing the petitioners by 20th of December, 20. Reply, if any, by 7th of January 2025. Stop. List on 14th of January 2025. Now, what is the interim order that you are seeking?
What I prayed for, kindly sees from paragraph page number 18 onwards. Mandatory injunction, to immediately, that's not there. Each one of them to purchase the interim injunction, that I prayed for is prayer number K onwards. Praying for injunction upon the order, the stay order of 16 January 2024 passed by the respondent number 2, that is the tribunal. Not to be given any effect to such.
Who is giving effect to?
Since the deed stood cancel, that order I am praying for stay of operation of that order.
And in fact, order has already been executed. Because the register, it is the report that the register already.
This cannot. Yes. That should not be given any effect to that registrar cancelling that should be the consequential step, should not be given any effect to.
Yes, there is a delay in preferring appeal.
The
But my
order
lord has-
passed by the
my lord-
order passed by the tribunal.
And all consequence steps that
Has tribunal cancelling the deed of gift has already been given effect to by the registering authority. Stuff next. The respondents are restrained from taking any further steps in the matter till 17th of January 2025 or until further order, whichever is earlier.
No, my lord, will your lordship be kind enough to keep the point?
Yes,
My lord.
the point of maintainability of the writ petition as raised by the learned advocate representing the state respondents is kept open.
My lord.
I'm deeply obliged. Only one line, with regard to the consequential steps, because the record of rights and all, they might change the record of rights.
Not to take any further steps has been mentioned.
Not to take any further steps.
I'm deeply obliged.
Hearing 17 and for the petitioner. First, give the affidavit of service, my lord. As far as the private respondents are concerned, they have never appeared anywhere, and as such, they have not also appeared in the stage also before my lords. And the entire plight of the petitioner emanates from the fact that the private respondents are not appearing. Now, why I am before my lord is a situation very precarious.
SLSA. SLSA.
Yes.
You are aggrieved by the order of any action
Lok
of
Adalat.
SLSA?
Yes, by the Lok Adalat. Upabhokta Lok Adalat. I don't know whether I should say I'm aggrieved or not, but yes, my registration of the property has actually been stalled because of an order which actually I thought was in my favor. My lord will kindly comes to the order once. Hello, that's it. That is at page 23, my lord.
Who are you representing? SLSA, my lord. SLSA.
My lord would find that an advocate commissioner was appointed since the respondent number 2 before my lord was not appearing. The respondent number 2, my lord, is the developer. Now, what happened? I'll just put it in a nutshell, the background. The petitioner has purchased a property. Now, this respondent number 2 was the actual developer. He died. After his demise, his business was taken up by his daughter and wife. But however, they were not interested to carry on with the business since they have already received the entire consideration from the petitioner. So they chose never to appear and never to register the flat in favor of the petitioner. Now, 3, 4 are the owners of the property. Now, before the Lok Adalat, they were duly represented, which my lords will find from the order itself. Now, what happened that before the Lok Adalat, the owners, the advocate for the owners said that we are ready and willing to execute the deed of conveyance in favor of the petitioner. We are ready to put our signatures. What happened thereafter that before when they did not appear, I had to put this into execution before the State Commission. Now, when I put this before the execution court, they never appeared. Now, my situation aggravated more because I had to then serve everybody because State Commission said that please serve everybody and ensure that there is non-compliance. So I had to serve everybody and it went up to the extent of paper publication also. In spite of that, nobody appeared. Now, what happened was the executing court found that this part of the order which says that Advocate Shampa Saha represents the OP number 1 on behalf of this court is erroneous. That the Lok Adalat has exceeded its jurisdiction by appointing a advocate commissioner only qua the opposite party number 1. Here is what I am agreed by, and my lord knows that it is only under 226 and 227 I can assail this part of the order. So what I am actually before my lord is a modification to this extent of the order, because there is already an application which I have preferred before the executing court where I have asked, or rather I have prayed before the executing court that an advocate commissioner be appointed and the deed be registered through the mechanism of the court, which the court does under 25 and 27 in the earlier act and now under section 72 of the new act of 2019. But this part of the order, my lord, has to be modified. Otherwise, the executing court is not being able to give me the remedy I'm looking into, my lord. And on the pretext of this order, my lord, I have already deposited 8 lakhs, my lord, because the flat is more than 1 crore. So there's a lot of money that is at stake, and I'm there since 2023. I'm stuck, my lord, without no fault of mine. So it is absolutely a bona fide purchaser who is before my lord. And it's absolutely, I'm in a soup, my lord.
Shampa Saha, learned advocate,
Yes.
was appointed as the advocate commissioner to execute and register the sale deed in presence of the parties.
Yes, ma'am.
What did you say the problem
She
with
was appointed. The problem arises that she was appointed only for OP number 1. So the
OP number 1? Who was the OP number 1?
One is a promoter, my lord, who never appeared. So it ran ex parte. Before this matter was referred to the
Who
Lok
is the
Adalat.
promoter over here?
Respondent number 2, my lord.
SP Enterprise.
My lord.
So Shampa Saha was for the
Yes. Or only for the promoter, yes. Because a learned advocate for the owners, which is OP number 2 and 3 appeared. My lord will find that the complainant and the OP number 2 and 3 are directed to pay 10,000. And the weird thing is that they paid the 5,000 amount. In spite of that, they did not appear before the registrar.
But then OP numbers 2 and 3 were not represented before the commission.
No, thereafter they never came. At the initial stage, they were there.
No, page 23, I don't see the appearance.
Yes. The complainant and the OP number 2, and that is a typo error, my lord. Because from the presence, my lords will find that that was a typo error, which we said, but the commission said cannot be rectified for some reason or the other, best known to them. But my lords will find that the complainant and the OP number 2 and 3 are directed to pay 10,000. This learned advocate, Mr. Das, was appearing actually for OP number 2 and 3, which would be evident from the order itself, my lord.
If the OP number 2 is in the owner execute the details. Neither in the order it is mentioned that 2 and 3 are appearing.
Only 7 except the last line, my lord. It's a typo error which we...
Where is the typo?
I understand, my lord. We have said this several times. They said they cannot change it. I don't know for what reason. It is so, what should I say? It's so confusing that here it says complainant and OP number 2 or 3 are directed to pay 10,000, and here it shows the presence is for OP number 1.
No. Even if a party is not there, the court can always pass directions for payment or whatever.
My lord, I understand, but since I was there, this learned advocate, Mr. Molay Das, was appearing for the OP number 2 and 3, which possibly would also be evident from the...
Learned
let me
advocate
find
for
out
both
any
sides
other
have
orders
submitted.
which... but since I'm agreed by this, I just annex this one. There were other orders of the State Commission in which it goes to show that Mr. Molay Das has appeared for 2 and 3, my lord. If my lord wants that on record, I can bring it on record to clarify this confusion that is arising. It's an obvious confusion.
So, respondent number 2, the promoter is not available.
The promoter is not available. Now the owners are also not. I went up to as far
3
as
and
web
4,
application.
3 and 4, they are
Not the
not
owners.
turning up.
They are never turned up.
Despite
After this, despite this
receipt
order.
of the money.
Despite the paying the money of the commissioner of rupees 5,000.
Right.
They never appeared. That led me to my execution case, which I have also annexed, my lord. My lord, for my this, my lord, will kindly come. The confusion would clear, my lord. Will kindly come to the execution application, my lord, that I have appended. From it runs from page 29. The relevant portion which might clear out this confusion would be, my lord. My lord would be at running from page 15 onwards, my lord. Will kindly, sorry,
What
page
is the role?
36, paragraph 15.
What is the role of SLSA?
My lord, since it's a lok adalat, my lord, so this is the authority, my lord.
No. Certainly not. Yes.
My lord, we couldn't find our role. We just organized the Upabhokta
Right.
and
They do not have any role to play over here.
My lord, whom to make a party with? I have to make a party to come before my lord. I just can't make the private respondents party since this.
Show me the legal provision under which you want an order to be passed.
My lord, they say they don't have a role except
Yes,
that
so
is
we
what
have
I was
to read
trying
out
to
the
show, section 7, which says that this is organization of lok adalats, every state authority or district authority or the Supreme Court. So this runs as section 7. May just I place, my lord. I'm sorry, my lord, I don't have a copy. I'll just place section 7.
Bring a copy.
I'll bring a copy and then. My lord, kindly fix up a date then.
Please come. None represents the respondent numbers 2, 3, and 4. Where is your service? Let me see.
Yes, ma'am. My lord.
Where is the service?
My lord. They were served, my lord, personally served. Personally.
Service will not do.
My lord, they
Affidavit of service filed in court is
My
taken
lord, they
up
will never
record.
appear. I have tried in every residence. That's the
Uh,
only way I could have was given by through a personal service. Because I
Let-
went as far as paper publication before the state commission.
Fresh notice be served upon the non-appearing respondents. Through the postal department. List the matter on 9th of December. Record the presence of the respondent number 1.
I'm grateful, my lord.
My lord, I am appearing for Reserve Bank of India, respondent numbers 1 and 2.
For respondent number 3 and 4, Bandhan Bank.
Now, what happened if your lordship would kind enough to come to, my lord, petitioner has, my lord, a current account. He is, my lord, doing business. Now, my lord, all of a sudden, my lord, the account, my lord, was frozen. My lord, we made a complaint at page, my lord, 1629 June 2024. Now, my lord, kindly comes to page 19. My lord, a message come from banks that our complaint has been registered. This was then, my lord, since nothing was done, my lord, page 20 kindly comes to, my lord, we write it to the banking ombudsman. My lord, after, my lord, this, my lord, kindly comes to page 23. My lord, we received this, my lord, based on your response, my lord, a complaint number, my lord, is closed. Is closed. Now, my lord, kindly comes to page 24. Now, my lord, we received this letter. Oh, after, my lord, this is a mail, my lord, which we has received, my lord, which says, we write it with your reference to your caption complaint, wherein you have expressed concern regarding your difficulty in operations of your bank account bearing number such and such held with our the Charial Bazaar branch. We have examined the matter and would like to apprise you that that freeze has been imposed on your above mentioned account based on the instructions received from the police inspector crime, Kharghar Police Station, Navi Mumbai, Maharashtra. It may be noted that since the freeze has been imposed in order to comply with the instruction received from law enforcement agency, and explicitly written instruction is required from the same law enforcement agency to remove the lien. My lord, this is the thing. For further clarification, my lord, I am not involved in any crime, no proceedings against me, at least not known to me, frozen.
Instruction notice, we received the notice, section 91. There is online fraud took place.
Committed by?
Regarding the account number 101700245797, and these details has been asked to provide these details.
Like you're a league computer.
Do you have extra copies of that? Yeah.
Please come.
My lord, so far as
Lord,
banking
I am-
ombudsman is concerned, because what my learned friend has just placed before your lordship is the email dated 7th August 2024 at page number 24. But this is not the only email which he had received. There was also another correspondence received by my learned friend's client on the 7th itself when the complaint was closed. That complaint which he had made to the banking ombudsman was closed under the provision of Reserve Bank Integrated Banking Ombudsman Scheme of 2021 under two different clauses, which he has merely suppressed in the
Not
application.
suppressed. We have got
That
it
is my
after filing of the writ petition. I have that.
this was communicated on 7th of August. Today we are in November. I
Yes,
don't know.
yes.
But
filing of the writ petition.
so nonetheless, the complaint will not lie because the relief which he has sought for before your lordship in the writ, that has been considered and that has been rejected because the regulated entity, which is the bank, concerned bank in this case, regulated entity has received a complaint and acted on the basis of the police complaint, and therefore it was rejected in terms of law under this particular scheme of 2021, my lord, Rule 10(1)(e) read with Rule 16(1)(a). I have brought one copy for your lordship's consumption. I'm sorry, I'm only carrying one and it's marked also, but nonetheless, I've marked the relevant provisions, my lord, for your lordship.
Likho. The petitioner's bank account with the Bandhan Bank, comma, Sharial Bazar branch has been frozen. Stop. The petitioner is aggrieved by the same. Stop. A complaint was lodged before the branch manager of the bank and thereafter before the banking ombudsman. Stop. The bank, the Reserve Bank of India, by an email communication intimated the petition. Email communication dated 26th July 2024 intimated the petitioner that his complaint has been closed in RBI space CMS. Stop. The petitioner was also forwarded with a mail communication on 30th of July 2024 intimating him that the freezing took place in compliance of the instruction received from the law enforcement agency. Stop. The petitioner was directed to contact the police inspector within bracket crime, comma, Kharghar police station, comma, Navi Mumbai at the email mentioned therein for further clarification. Stop. According to the petitioner, he has not been made aware of any criminal proceeding pending against him. Stop. No order of freezing by any court of law was ever intimated to him. Stop. Paragraph. Learned advocate representing Bandhan Bank relies upon a communication dated 3rd of January 2024 by the Kharghar police station addressed to the nodal officer of the Bandhan Bank intimating that the Kharghar police station, Navi Mumbai, is investigating a case registered VIDE CR number 428/2023 under section 420 IPC read with section 66 within bracket D of the IT Act 2000 alleging online fraud. Stop. The account of the petitioner has been misused by unknown accused person by forcing the complainant to deposit an amount of rupees 4,49,923. Stop. the details of the bank account of the petitioner for further investigation was required, and there was and freezing of the account was called for on urgent basis to prevent further crime. Stop. Next. Learned advocate representing the Reserve Bank of India relies upon the Reserve Bank Integrated Ombudsman Scheme, 2021, which resolves 2021 meant for resolving customer grievances in relation to the services provided by the entities regulated by the Reserve Bank of India. Stop. Paragraph. It has been submitted that on receipt of the complaint from the petitioner, immediate action was taken. Stop. The freezing took place only because the police is investigating into a fraud where the bank details of the petitioner have been used. Stop. Paragraph. Upon hearing the submission made on behalf of all the parties and on perusal of the materials on record, it appears that the bank account of the petitioner has been found to be involved in some online fraud activity. Stop. The details of the case number and the investigating officer are known to the petitioner. Stop. Paragraph. It will be open for the petitioner to approach the forum where the criminal proceeding is pending for necessary relief. Writ petition stands disposed of. Brief.
Only one thing.
Service is taken on record.
Only one thing. One judgment, my lord, on the same self issue, my lord, lordship would kind enough to call.
What is there in the judgment?
So, my lord, it says, my lord, from this kindly see the mail, my lord, which has been shown. It's on 8 January 2024. We are almost in the end of the year. My lord, we do not know when, my lord, the investigation will be complete. When it is not, nothing. From the first time we come to know 91 was there. My lord, it says not this cannot be done because this was also a business account. My lord, ultimately, in view of the order of the Honorable Supreme Court in 2024 SCC Online Supreme Court 895, court directed the petitioner to furnish a bond with the petitioner and to defreeze the account.
You go and approach the court over there and obtain orders? Why from here?
No, my lord, it was done by the High Court itself.
It doesn't matter.
It was done by the High Court itself. My lord, from January, my lord, it was, my lord, first time, my lord, before your lordship, this is being placed.
My lord, this is not, this is a submission made from the bar because
it is
the
not
letter, the letter which was suppressed, as I pointed out to your lordship, which
Or it
clearly
was on
mentions,
July.
it clearly mentions the Reserve Bank of India banking ombudsman had indicated on 7th of August at the time of closure of the complaint that it is observed. I'm just placing from the letter itself, from the RE's submission, that is regulated entities submission, that the freeze has been marked due to notice received from cybercrime. So he was made known that a
Cybercrime, entire
crime.
India from Kashmir to Kanyakumari,
Very
where
well, but
cybercrime will
it
go.
is not something that he's coming to learn only here and now that something has happened. It was on his part to carry out the
Where
necessary.
from will I know?
His submission is that if
He was not
the
informed of the
that apart,
Yes.
he wants defreezing by
yes,
by giving a bond.
yes.
This is what his prayer is now. What will be the submission of the bank with regard to this?
The bank will.
No investigation, the police is investigating, no difficulty. But the amount, if the petitioner keeps a bond, this is let me see the order of the Supreme Court once.
No, my lord, I have the order of the High Court, my lord,
Let me see.
following Supreme Court.
Can I get a copy of it?
There you go. particulars টা আমি পরে নিয়ে আসবো আজকেই দেখতে দেখতে পেলাম তো WP
Just a minute.
kindly
But
see
whether it is in the same state,
no Madras High Court Madras
this
Following,
is
my lord,
Madras
kindly
High
see-
Court, but the
so
proceeding,
paragraph 6 my lord
but the proceeding was the proceeding pending before the Madras state of Madras.
yes state of I'll kindly see the issue by many of the citizens
No,
currently face is the freezing of an account on account of the instruction of local police or from the National Cybercrime Portal. Many a times the account holders have been taken into surprise that by such order of freezing, before they could realize as to why and for what purpose the accounts are freezed, enough damages are caused to their day-to-day financial life. Since the very lifeline of the business gets severed by such unilateral orders on account of freezing passed by the police. Then Millard kindly see the last page. Millard, all discussions were made. Then Millard kindly comes to Millard page para 7. Then Millard para 6. Unfortunately, in most of the guidelines issued by the circular not observed, later on an identical issue came up for consideration before this court in WP number such and such, considering the dictum of the dictum laid down by the Honorable Supreme Court in such and such, directed the petitioner account holder to execute a bond undertaking to deposit the amount in case the money found in his account is a tainted money and liable to be forfeited. Ultimately, the Honorable Millard Madras High Court directed bond to be furnished and Millard directed the authorities to defreeze the account.
What I find from paragraph 7 of my learned friend, the judgment, in the facts of that particular case, the amount was very minimal. It was 2.48. And on that consideration, it was said that very well.
How Reserve Bank of India is affected by this?
No, because Reserve Bank of India is ultimately the watchdog of the economics concern. So naturally,
I will
and
produce a
because
bond.
there is already the regulated entity involved,
Produce a
which
bond.
has requested the account to be frozen. What the circumstances are, nobody knows. At least
what is
Reserve
the
Bank of
amount?
India does not
What is
know.
the amount involved over here?
Millard, Millard,
There is the communication
The
from
particulars
the bank.
at least are not there available
The
with Reserve
bank
Bank.
my
communication
account
is there.
Millard, the last
Figure is mentioned.
4,48,000. It was
4 lakh.
49,000.
Yes, 449.
Millard, I do not know, Millard, from 8 January now, Millard, it has been supplied to me. 8 January 2024, we are almost at the end of the year.
No, but then see,
And
you were intimated to contact the police officer who is conducting the investigation, the case number and everything is there. Why don't you get an order from there?
Definitely, that is a different aspect. Criminal
Yes, you
aspect,
can get
if
it.
Millard summons are sent to me, Millard, I will go appear, whatever is that is a criminal aspect. Now,
That
this is
means
with
you have
me
to
with the
wait.
bank only.
You have to wait. If you wait for the summons, it's different. You have been requested to make clarifications. You can approach before
Definitely,
the
Millard,
court.
Millard, kindly appreciate, Millard. This point was also taken before the Honorable Madras High Court. But Millard, kindly, Millard, the first paragraph says, Millard, the very lifeline, Millard, becomes, Millard. Kindly see the language, first paragraph, Millard.
But then thing is,
citizens go.
you never know, this account may be used for further crimes also. And maybe this is the reason it has been frozen.
My lord, this is
No,
a
no,
current
that's why, Millard,
account.
that's why,
This is a
Millard, I am-
current account in the name of Ma Jogeshwari Lottery Agency.
Yes.
It's a matter of lottery. We don't know what the repercussions would be if we defreeze. What my learned friend is beseeching before your lordship is seeking the blessings of this honorable court. In my respectful submission as Reserve Bank of India, it's my respectful submission before your lordship that let it be decided in due course in the proper forum. If he's aggrieved, he was provided with
whether
the
a
matter
decision,
details.
final decision comes or not, you can
That will
approach
be
the
a
proper
subject matter
forum.
of a different forum. Grateful to your lordship.
Your lordship, I apologize for mentioning out of the turn, but your lordship, this is a
Harinamda,
urgent matter.
judgment.
Just minutes of your lordship.
Which item is
Your
it?
lordship, this is item 30 to 37. There are 8 writ petitions which has been filed, and it has come up after months, your lordship. What we are suffering here is that my accounts, all the 8 in the 8 writ petitions, all my accounts have been frozen from past 2 years. Your lordship, what the ED, the Enforcement Directorate authorities have done, that without issuing any show cause notice to us, they froze our account. Section 5 of PMLA Act is very clear that after 180 days, my account will be reopened. But over here, it has been more than 400 days have passed by. Now they have got the order of further extension. They only did the search and seizure under Section 17 in April 2024, and my account has been frozen since October 2022. Your Lordship, all I'm seeking is your 5 minutes of your Lordship if this matter can be taken up at any day.
Is your other side here?
Your Lordship, no, but we have served the notice. Union of India, Lordship.
You are there. Give me
Lordship,
the
I
file.
can take the undertaking of informing all the other parties, Your Lordship.
Who are the other parties?
Enforcement directories and the bank, because my bank accounts have been frozen. They only
Very well.
received the letter.
Upgrade the matter tomorrow. Item numbers 30 to 37. Please intimate all the parties.
Yes, obliged, Your Lordship.
Item number 25.
Yes.
It was mentioned that
Huh?
the next date of hearing before the learned commission, that is the
Which commission?
Consumer
Yes.
tomorrow, the date is fixed. So I found in the brief there are certain allegations against the president of the commission regarding the bias. Lordship, this matter was upgraded already. It's item number 25. Can it be upgraded tomorrow, Lordship? That much.
If tomorrow it is upgraded, then how will the order be passed? And how will the hearing? If tomorrow is the hearing, it has to be adjourned.
It has to be adjourned. In that case, I will communicate, Lordship. That much I can.
Communicate that the matter is pending, they'll adjourn it.